When was the order passed?
This honorable court will already handed out, already 5 months over. Now, child is in the custody of the mother, she is studying. Now, the repetition, the grievance is not be given the custody. Now, this repetition does not serve for consideration. Number two, whenever the matter being discussed before the family court.
No, what do you want right now?
That's more, the matter may be taken up is for a disposal, but does not serve for consideration. More. Because their family court, we are charging the proceeding. Therefore, this repetition has to be disposed of.
Filed by whom?
But filed by husband.
Filed-
Order passed by the family court. No, I won't give the custody check. This all before they have to pass an order and direct it to the.
No, if nothing survives, then there is no urgency.
No. Before the family court, my repetition is pending in the. We say the.
Yes.
My lords, with your permission, maybe if matter, my lords, it's an employment dispute. It has been rejected as lack of jurisdiction. That has been challenged here, my lords. We have complied all the office objections.
If the office objections are complied tomorrow. Yes.
Obliged, my lords.
With permission, my lords. Matter for being spoken to, my lords, in this matter.
Tomorrow. Yes.
It's an appeal against enhanced compensation for land acquisition, my lord. Execution matters posted on 30th. May I request Monday or Tuesday, my lord? 2024, my lord.
Monday, Tuesday.
Please.
Yes.
Epilepsy matter, my lord, I am for harassment, a maintenance matter.
Chair.
Tomorrow,
Which year?
23,
What is the urgency now?
admission. Notice served.
Post this matter on Wednesday.
Lords, one miscellaneous first appeal. Suit is for declaration and injunction. We are putting up construction in the property. Identity is in dispute. Now, because of the interim order granted by the court
When was it granted?
in 2024, my lords. Our notices have been ordered.
Wednesday.
Much obliged.
I filed a memo for withdrawal of the above petition. Therefore, taken on Tuesday, madam.
Closed. Yes.
Obliged,
call- Call the list. It not appears too much. Call the list.
Serial number 1, A. Madhusudan Rao, for petitioner, A. Vijay.
Lords, sir, challenge the order passed by the family court, Chikmagalur, whereby a maintenance husband petition. Maintenance of rupees 8,000 has been ordered. my lords. My client is a tailor, my lords. She has claimed 25,000. What has happened before the trial court is that though we appeared, we could not file objections. I'm only seeking that the matter may be remanded and I may be permitted to file my documents. She has not produced any document before the court to indicate that he has any.
Where is the counsel for the respondent?
He appears at the, my only.
He was not appearing.
He has appeared on some of the days he doesn't appear. I don't have an interim.
No. Paso.
The afternoon there is a file.
Yes. Post this matter on 10th of September.
Serial number 2,
Yes.
serial number 2, Anaprakash VG, for petitioner, Raj Prabhu.
Respondent may be.
Directed me to secure a copy of the,
What has been?
sorry, my lords, today morning I received the.
Take that. Have you served him a copy? Have you served him a copy?
I've also in the morning.
They came now.
Where did she say about that clause number? Have you seen that?
The morning, the mail was sent to me in the morning.
Password?
I will file an application, please, your lordships. Now that the school is being commenced, to be commenced from the first week of September at Dubai, please, your lordships. They are preparing themselves to get the child admitted there in Dubai now, again, even in spite of the order of the court here. So I am filing an IA,
Supreme
copy
Court
has
order.
been served on the other side, please, your lordships.
In that case, may I
Not
request
any
that
To
objection.
understand there, you have to make a mention before the Honorable Apex Court.
But we have already done it, please, your lordship.
Clause number 3 or 4, which says that the girl shall be joined in the in the school at Bangalore. That, and she has to go communicate to the school and all. No, she has done it even before going to the Supreme Court, even before
Certainly.
leaving the country. No, that particular order is stayed by the Apex Court. Now, if this court says, let the girl come to Bangalore, what will she do?
No, I understand, please, your lordship. This submission we have
That's why-
already made before the
That's why-
Supreme Court.
That's why, because now that's why I wanted to see this, whether she has stated anything about before the apex court, that already that worked out, that clause number 3. If it is not, no, a judicial discipline requires that the court cannot.
Certainly.
That's why you please get a clarification from the apex court. You make a mention, do whatever you want. Then basing on that, we will, now, as far as the mother is concerned, that the things will be, no, even on that day, permitting her to leave the country is also because the girl was studying in
Certainly.
Dubai.
Yes, please, your lordship.
So
Now
that's the only now which is coming in the way of the court.
I accept, please, lordship. If lordship may permit to place this IA on record, let them file their objections in the due course. Anyway, he is seeking for an adjournment now. So in the meanwhile, I'll also peruse through the records what I have received now, and I will accordingly submit it tomorrow, please, your lordships. If this IA is taken on record, please, your lordship.
Today they
From
they
this-
filed this IA today, wherein I understand, just now it was given to me. You kindly see the prayer what they have sought from Lords. Restrain the petitioner or anybody claiming under the petitioner from admitting the child in any other school outside the jurisdiction
Of Bangalore, yes.
of Bangalore.
Because now I've already paid the fees in Bangalore, please, your lordships. And they have also given an NOC to this school in Bangalore to get the child admitted.
No,
On their instructions, I have already paid the fees, and in compliance of the order of the court, I have paid the fees. Now again, if they
All
continue their
foreign shopping.
education,
I am totally agree with that, Lords. My only difficulty is
Fortunately, courts, oh, she has solved.
I understand, Lord.
suppressed
This
all
is
the
more or
facts.
less bench hunting, Lords, which
You
should not.
appear the court, what are the suppression?
we have
that
already
has been
filed an
made?
application to vacate the stay also, please, your lordship. The Honorable Supreme Court has said that anytime this week or next week, the matter will be taken up, and the notice has also been
Lords, in that
asked to be
case, it's
served
not
on-
listed this week or whatever. Let the matter get disposed of, my lord, so that it will be easier for us to assist
please
my
be-
lords to.
No, it unnecessarily gives it's two different orders.
stay on record so that
You file it, you file it. No, what will happen? What is the, what is what the court should do with that? Nothing is going to happen with that or with that IA. No, when the Supreme Court has stated so and so clause, no, she can't be in she cannot be joined in schools in Bangalore. Why should the court ask her to come now?
no, we are not insisting that she should be
No,
brought
what
before
you're
this court
insisting
now.
is that she should be here, not there.
No, my humble submission is I will get with respect to 15(3) and 4, I'll get that resolved before the Supreme Court, please, your lordship.
Once you get
But
the, once you get
parallelly-
the clarification from the apex court, everything has to fall in line. And she has no other option but to come to India. She is only trying to take advantage. What advantage she took? She is now enjoying it. Now, once it is, all these are brought to the notice of the Honorable Apex Court, it will be taken care of by them.
My
And,
only grievance is this, please, your lordship. If again the child is got admitted in the school in Dubai, and purpose of filing
I
this petition will be defeated.
I understand what is your.
That is my only grievance, please, your lordship.
But the thing is, we cannot do anything in that. Because that's a whole, we should have gone to the apex court much before.
In fact, we had last week itself, we
Now,
have
if you
moved
look
it.
at the order
Unfortunately,
says it is arising out of a final order from the High Court.
The SLP amendments, Lords. I'm not sure, my lords. Nange Belege it was
It's order that is placed before this court.
the order passed by the honorable. Court, my lords.
It says on the top.
If this IA is taken on record, I will make a submission to that effect
Yes,
to the
Lords.
Supreme
It
Court.
says
and
arising
get
out of
it
the interim
resolved.
final judgment. That's an error, my lords. It can't be.
So that I
Yes.
can, if this application is there, I can request the Supreme Court to take up the matter ASAP so that, please,
File it, not here.
in the
Section.
counter, will get this.
Yes, file it.
Please.
The poses matter. When?
Tomorrow is what my learned friend is asking for.
What tomorrow? Tomorrow. No, whatever are your difficulties, no, in order, now the court can't pass any order,
Certainly,
only for
please,
that clarification.
May I request the court to accommodate somewhere on 27 or 28, please, your lordship, so that in the meanwhile,
I don't think you can, but still,
I'll try my level best with the
28
Supreme Court
post
to
on
get this
28.
listed.
it is submitted that the matter is likely to come up before the Honorable Apex Court.
28th, if a date could be fixed. please. 28th,
28,
please.
yes, next.
All right.
Bill number 3, Prakash K.A. For petitioner, Muralidhar H.M.
No representation on behalf of either of the parties. Pose this matter on 14th of October.
Sale number 4.
Yes, my lord, we are for the petitioners.
Yes.
Nagendra Nayak.
We have filed that assets and liability statement as instructed in the earlier sitting.
My lords, in this matter, I may be permitted to file memo for retirement in this matter, my lord. No instructions from the client. Hence, my lords, I may be permitted to retire from the case, my lords.
Where is, when you are filing now?
We are filing.
File it in the section. Come.
Please.
The land council for the respondent submits that they are going to file a memo for retirement. Pose this matter on 28th.
My lord, a small submission that that MC pending before Monday court is listed for orders on 29th. Maybe listed after 29th.
After 29.
Yes, instead of 28th.
3rd September.
Okay, oblige, my lord.
Sale number, preliminary hearing, sale number 5.
Appearing for the
Pratap Singh
petitions, my lord.
Kapoor.
The council is on in C, my lords.
Ladyship, Ladyship, this is the case which was listed yesterday. Ladyship was pleased to remove the objections. Ladyship, the prayer in this matter is to expedite the divorce proceedings within a time-bound manner. The reason
When is the MC filed?
MC was filed, Ladyship, in 2022, 13th of
Wow.
April. Now,
Why should we expedite it?
Yes, I'll tell you why, Ladyship. Ladyship, this is a case, it's essentially a child custody matter. Now, what is happening is that despite repeated orders passed by the guardianship court, upheld by the Honorable High Court, the mother is not giving me any access to my only child, only son, who was born after 7 years.
That is, if she is not giving access, that is a
So, Ladyship, I'll tell you what.
the remedy is different, not.
I understand. No, I'm giving the background, Ladyship. Now, that is my major grievance for me to file a divorce petition. Right now, I am out of my own house. She is staying in my property. I am staying in rented accommodation. Despite several orders passed by the Honorable High Court, upheld by the Supreme Court as well, she is not giving me any access. So, and what is happening in the guardianship in the MC case is a lawyer comes twice. The right to cross-examine has been closed. The paramour also, they are in conspiracy. Repeatedly, their rights have been closed. They move a memo for recall. It is 1,000 rupees cost is imposed and they recall. But several dates have passed and she's not cross-examining. The lawyer comes in because we are Christians by faith. She makes random questions like, do you know the 10 commandments? Just to delay time. And this has been going on for months, which is why we've been constrained to move an application in this particular case for a time-bound disposal. She will see the orders, number of times their rights have been closed. Then they come on the next day. Then she comes to the court herself, the lawyer, and say, today I'm not feeling well. I cannot cross-examine. And this has happened on 3-4 occasions. It's already mentioned in the order sheets. They're just wanting to delay the matter. So somehow I get frustrated. I give up on my child. I agree to whatever she says. And
even the petitions which are filed in 17, 18, 19 are also pending before the courts.
Ladyship, the 2019, there was a
2019 matters, they are going to clear all the 2019 pendency. Now, out of the way, court cannot pass any order to decide.
Ladyship, my only point is that the way the matter is proceeding.
If she is not complying with the orders of the court, not giving not permitting him to meet the children, you have a remedy.
No, that is a separate issue. That is only a background I gave, Ladyship. Why I filed for divorce? I was only wanting to meet my child, but when she made it so difficult and being in contempt of various orders of the court, I filed an MC. There's also a case of adultery. The pastor of the church where we were visiting, she was in an adulterous relationship with him, and he's a party to the case. Now, sometimes the pastor's lawyer takes a date, sometimes she takes a date, and they're both in collision with each other. And what is happening is that this matter is just dragging on. And Ladyship, my point is, what is my fault? I have finished. I am the only witness in this case. I have given my evidence 1 year ago. And Ladyship will see 10 dates have gone.
Please come.
Yes, Ladyship.
The present petition is filed. Seeking a direction to the family court, Bangalore, for expeditious disposal of the divorce petition, MC number 2422 of 2022 in a time-bound manner. It is a case of the land counsel for the petitioner husband submits that the wife on one pretext or the other has been dragging on the matter and is not cooperating with the trial. It is also submitted that she had failed to comply with, honor the orders of the or honor the orders passed by the court, by several courts. And the father is not able to see the children.
Child, there's only one single son.
Child.
Yes.
In
Yes.
in those circumstances, unless this petition is disposed of at the earliest, it will cause lot of injustice to the petitioner husband. The next the Honorable Apex Court had time and again had passed orders wherein the courts are restrained from passing orders directing the trial courts to dispose of the matters unless in exceptional cases. This is the MC of 2022 and this is pending in the Family Court Bangalore. There are several cases which are pending, which are much prior to these cases, and everybody's problems revolves around these issues, and there cannot be an exception to this case. And this court finds no reasons. And the next para, this court has specifically directed the courts to complete the pendency by 2019. And at this stage, if again for a 2022 matter, out of the way, there cannot be any order, else this court finds no reasons.
Leadership may make one statement, leadership will record one thing, there should be no unnecessary adjournment sought. Leadership has recorded that in cases with.
Court is not inclined to pass any order fixing a time frame. However, submitting considering the submission of the land counsel for the petitioner, the court shall proceed with the matter without granting unnecessary adjournments.
I'm so grateful, H. I'm so grateful. Thank you.
Yes. IA1 of so-and-so is filed to dispense the production of the typed copy of annexure A, B, C, D, F, and G. The IA is allowed and dispensed with. Yes.
I'm so grateful, H. Thank you.
Cell number 6. Ongoing dash for
This is the petitioner.
Lord, we have, but on the last occasion, my lord, your lordship said Lord, change the order from daily visit to Lord weekly visit for 4 hours. That is on weekends. But that has been going on. Meanwhile, your lordship had asked them to tell your lordship how much they are willing to pay for the maintenance.
Lord,
No,
I think
whether the visitation has went on well or.
very well, Lord. The father and children are, Lord, are bonding really well together.
No, in
Lord,
fact,
direction
Lord,
was, your lordship,
we have brought the child, the son here, my lord. Your lordship wants.
though
to-
he has school today,
Doesn't matter.
no, for
We
when
have brought
father,
because there is a date to.
Lord,
There
your
is the issue. That is
Your
why.
your lordships have not directed the children to be brought to court. My lord, if your lordship, no, if the allegation is that children are not comfortable, my lord, I can place, my lord, the video on record before your lordships. The way the children.
No, is it your case that the child is not comfortable?
No. It's not that he's not at all comfortable, but the father goes on recording his video and he's getting intimidated.
There is,
And
What is happening is in these matrimonial proceedings, unfortunately,
Correct.
everybody is the wife or the husband or in the process of collecting evidence.
Evidence. Why?
Instead of
And
enjoying-
he's actually
No, when the
tutoring the
visitation-
child.
Lord, the only day the video was.
He's
taken was the-
actually tutoring the
I'm
child.
sorry, my lord. The only day the video was taken was when he saw his children for the first time after 1.5 years. After that, not a single video has been taken. The photo, in fact, has been taken by the nanny of the children who accompanies the children to supervise, my lord. She's taking photographs on my phone and those are the only pictures I have. One picture a day is what she takes. There is no other video. Lord, if the child is comfortable, my lord, where is the need to make him miss school and bring him today? Except, my lord, if the impression to be created before your lordship, the children are not comfortable.
No, I am not at all saying that
is
he's
not
not
the
at all
allegation.
comfortable.
Then, my lord, where was the need, my lord? It is a question I ask, my lord, myself and also the parents to make him miss
No,
school.
anyhow, no, this father meeting the children should go on.
Your
So what
lordships are
about his
Yes.
part of?
Lord, your lordships are directed, Lord, since some claims were made on the last occasion that I earned 10 lakh rupees a month. I have, Lord, said,
Not that, not whatever they ask, you can't give.
your lordships directed them, my lord. The direction is to the respondent to
Hmm.
place material on record to show my finances.
We have placed, my lord, what is the diary number? We have
Father
placed some
can meet
additional
the
documents, my
children
lord.
on Saturday and Sunday. The mother should not be present. Any kind of disturbance by both the parties will be viewed seriously. The wife shall file all the documents pertaining to the husband's income. And copy shall be served on the council by the date of hearing. If there are any objections, the same shall be filed. When did
We
you
have filed.
serve him?
When have you filed?
Day before yesterday.
19th.
Knowing fully well that my client was traveling from Monday until last night. Copy was served only on Tuesday morning, Lord, though your lordship's order says by 14th of August.
No, without going into all
Yes.
that, please tell the court, what is that he's going to do? No, he's paying the school fees.
Yes,
And he's paying the house rent.
Yes.
So apart from those two, what about the
so the last
children's
application I said, Lord,
expenses?
20,000 rupees a month is what I said last. Lord, my salary is 3 point, I will place, Lord, every single salary slip. May I make this request, Lord, if it appeals to
The
the court?
salary is how much?
3,94,000 rupees per month, Lord. I have
At 94,000.
Yes.
How much you're paying right now?
2,35,000 rupees is what I'm paying only for rent and educational expenses.
Now, what is the material you find?
Lord, we have produced, my lord, obviously, my lord, we don't have access to the records, my lord. But we have, my lord, September and October's, bank
Mother
statement.
is not working.
Mother is not working. My lord, she had not worked for, my lord, last 10, 12 years, my lord. Because of, after the children were born, the husband did not want her
The
to
age
work.
of the children.
My lord, 10,
Eight-
10, 8 and 10 years.
No, for 8 and 10
10 and five,
years.
10 and
I don't think
10
mother
and 5, I'm
has to be,
sorry.
mother has to be at home to take care.
No, Lord, when the first child was born, Lord, at that point of time, she was earning, she was working. The husband, Lord, said, stop working now. Now, Lord, she quit work. After that, they had another child.
From how long all this started?
The problems, Lord, the problems only started 1.5 years.
She should have made some effort.
Lord,
No, it may not be, you may not get a job. Maybe what you were doing at that point of time with all
oh,
the
she is highly
qualification.
qualified, Lord.
She would get, no, husband is already contributing 2,35,000.
No, 1 minute, Lord. Let me tell about his salary, Lord.
Yes.
He is a director in Ernst & Young. Now, Lord, the salary component, what they are saying, Lord, is 3,92,000. Apart from that, Lord, 3,20,000 rupees is perks, Lord, which is on their own affidavit, which is available, Lord. I can show it from their own affidavit filed before the lower court. Now, apart from that, Lord, there is something, Lord, called flexi plan, which is about 1 crore in a year. Now, kindly imagine a man who earns only about
Have
3.
you file your bank statements?
Lord, may I make this request? This is what I'm going to make this submission. Let her file her affidavit of assets. My lord, I will also file my affidavit of assets. Your lordship will have everything on record before the court. Let them file their affidavit of assets. I will also file it.
We've already filed.
We've already filed in
No,
the lower.
Lord,
court.
my lord, let them file it before this court.
Yes, we will
Your
file.
lordship will see what kind of statements have been filed before the court below.
We'll
Let-
file, Lord.
Fresh
But-
affidavit, my lord, I will file, let them file.
Submitted
Lord,
that.
I have one request. Lord, let him file a certificate from his employer about the cost to company. Lord, in these corporate things,
Yes,
Lord, what they do is they split up the salaries so that, Lord, they don't have to pay the income tax, Lord. So the actual thing that is that will come out, Lord, is when the employer gives a certificate of cost to company.
Lord, I have it with me. I will file it along with the affidavit of assets. and
Cost to
liabilities.
company.
Absolutely.
Yes. No.
Let them, no, we'll both file affidavit of assets. Your lordship will be aware of what is available on the other side and what the petitioner has. We will file our affidavit of assets.
Yes, what about the visitation?
Lord, Lord, now I'm grateful to my learned friend, my lord, says that visitation is going on well. Lord, my parents have not met the children for more than 2 years. My parents also live in Bangalore. More than, not they're in their late 70s. Lord, can you permit me to take the children, my lord, this Sunday, the morning, and drop them back in the evening, my lord? Overnight could be considered after we file our affidavit of assets and liabilities.
This child is here, my lord. Your lordship may kindly have an interaction for even for 2 minutes if your lordship can spare, my lord, at whatever time, at lunchtime or anything, my lord. And then your lordship may take a call. I am not going to, as an officer of the court, my lord, I will not come in the way, my lord, of either the grandfather's meeting. Your lordship may talk to the child.
Why the boy doesn't like the grandfather?
According to now, what is being told to me in my ears now is that he doesn't like. But I don't have any reason to believe.
Why, what the grandparents have done to him?
I don't.
So right now, the father is misbehaving, using swear words and all that. So he's intimidated. He doesn't want to interact as much with the father. But that you can't say, unless he keeps meeting children, you know, that.
Page 47, 48, 49, the last time the grandparents with the grandchildren.
They've been talking.
No, if this weekend, my lord,
That's the last time the grandparents have met the grandchildren.
have to accept. No, please, can't go on like this.
47, 48 and 49.
Yes.
Lord,
Sorry, 50, 51.
Lord, the instruction that I have, Lord, I have also, Lord, I rely on the instruction that have given to me. I have not interacted with the child. Is that, my lord, the father, my lord, has some psychological thing. Lord, we have produced the certificates and other things, but those are matters, of course, my lord, on a future date, my lord. At the moment, my lord, the aggression that is being shown, my lord, the child is being affected by that is my instruction. He is
Grandfather.
actually tutoring the child. He is telling him, why are you wearing this kind of clothes or that kind of clothes, or why you're not wearing this, or, and my lord, he is.
What is wrong in it?
Also about
think
the
that-
cases.
What's wrong in telling the girl
What
child that
cases
you
also?
wear a better clothes?
No, no.
But being a father, you can as well tell him.
He's telling the child about the cases.
Yeah, he is discussing the cases also, I'm told.
Not this. I think it becomes apparent to the court what the effort is. Not, my learned friend says visitation is going on very well. Now, not because your lordships are asking the question about grandparents, that's where the crux of the problem lies. 498 case filed against the grandparents. Police find no evidence. Kidnapping case filed against the grandfather. Police this honorable court dismisses the case against the grandfather. There's a cheating case filed against
Grandmother is not there.
in 498, grandmother also was there, my lord. 498, police said there's absolutely no evidence against the grandparents for 498. Cheating cases filed against the husband and the grandfather. Forgery, cheating. This honorable court quashes the case against the grandfather. My lord, there's a kidnapping case filed against the husband and the grandfather. Police will not drop charges against the grandfather because it's matrimonial. You're not saying, my lord, there was no, not, my learned friend was gracious enough, fair enough when visitation was restricted to the father alone. The minute, my lord, I made a mention that the grandparents also want to see the grandchildren. Not these allegations.
I'm saying, no, I'm not saying that. I'm saying this weekend, please bring your father and mother.
Look, they're 75 years old, my lord.
Lord, but giving, Lord, taking them out of the thing, Lord, I don't think my client will agree to that at this stage.
Her consent, my lord, is immaterial. Your lordship is exercising
I'm saying, please
jurisdiction.
bring the parents.
This is
Bring
where
the grandparents.
The mother.
Thing is, she cannot say, I like this, I don't like this. You don't like it for what?
Lord,
No,
because
you-
there are issues, my lord.
If
Lord,
the-
kindly consider this, my lord. Lord, they have lived, my lord, in US, they have lived, my lord, in Switzerland. Lord, all the earnings that was there, my lord, was transferred to one account in SBI, my lord, in Gurgaon. That SBI account was in the single name of the lady, my lord. Now, what the husband does is he writes emails. We have evidence of all that. He writes evidence of, he sends emails, converts the single thing without her consent, forges her signatures, and my lord, today all the money that is lying there, my lord, is blocked. She is actually living on, my lord, the help from her father, my lord. She has no job. My lord, on 17th, my lord, when the lower court, my lord, wanted to pass some order for maintenance, they, my lord, objected. They did not allow the court to pass any maintenance.
Let the court understand the issue like.
Yes,
this.
my lord.
No, the financial issue is one aspect. And the children and visitation is another aspect. That's a responsibility of the father to take, he has a right to see the child
Yes.
and a responsibility to pay the maintenance.
Yes.
No, both the things the court has to balance.
Yes.
No, either for the father or for the mother, they can't choose to be unreasonable.
Yes.
Father cannot say that I will only have the visitation, but I'll not take care of the responsibility. And the mother cannot say, let father pay all the expenses, but I will not give him the visitation.
No, I'm saying.
There should be a balance in that.
I'm, Lord, I
And she
totally bow
cannot,
down. I bow down. There should be balance.
Yes.
And I am saying, Lord, for balance to
See,
be
what is
struck at this
happening-
point of time.
What is happening in all these cases is they're completely losing the balance. They're only able to look at the things only from their point of view.
Lord,
So what is happening is, okay, everybody in a family where there are disputes or no disputes, something or the other which is not of their liking do happen. So then people do give chance to the other spouse to, to get out of it or to rectify their mistakes. No, it has started. Don't tell the court about what has been happening. No, you're before the court and the court is monitoring
Lord,
what is happening.
Lord, I myself made the thing. Lord, let the grandparents visit this weekend. Lord, I have I'm not saying anything about that. I'm saying let the grandparents, if his thing grievances that the grandparents have not met, let the grandparents meet this weekend.
No, this week, I think from the last 2 weeks it's happening.
3 weeks, 3 weeks.
3 weeks it's happening. No, forever it won't happen like that. No,
No, no,
once when,
Lord,
for 3 weeks when things were happening, little, no, please understand. No, she wants something. We'll make him to do it. You also do something. Well, he has to now, we'll look into all that, whatever the statements that he has made before the court are not right. Initiate appropriate proceedings against him also. Because nobody can, just like that come to the court, take an order, and when it is not convenient, give some statement before the court, which is not right. But what the court wanted, there should be when you have come before the court and asking a relief, be fair and give it and leave it to the court.
No, we didn't come here. Lord, we have approached it, please. Lord, Lord, the lower court was to pass the order on 17th. What happened, my lord? They did not permit.
No, your lordship in the last occasion.
No, we'll do like this, Mr. Govindraj. Let everything be on record.
Yes.
After that, looking at the bona fides of your client also.
Very well, my lord.
And her interest also. And we will pass a balanced order.
No, I am
and
not
it cannot happen like how she wants. That she has to.
Now, they
understand.
came here before your lordship, my lord, saying that please expedite IA number 2. Now they went and withdrawn that IA.
No, I don't know.
They tried to withdraw.
My lord,
They filed an application to withdraw.
My lord, but
It is just
with
to, my lord.
with great respect, my lord, we are jumping from one issue to the other. Your lordship's simple question was, what is the problem if the father takes the children and makes them meet the grandparents? That question has not been answered. Money, account is frozen. Let us focus on one issue.
Fortunately, both the parties are not, they are not, now they forgot about what has happened and what has now, those issues are going somewhere here and there. Not good for either of them. And father should also be.
I have come before your lordship. I have said before your lordship, Lord, I will place everything on record. Whatever order your lordship passes, my lord, I will accept. Lord, the suppression.
But no, you file all that. We'll look into that, and also a suitable order for the custody, for the visitation rights, or overnight custody, whatever it is, it will be passed. No court will not wait for the mother's consent. What is acceptable to her or what is acceptable to his client is not the order what court is going to pass.
Your lordship ultimately becomes, my lord, the guardian of the children. That's what the Honorable Supreme Court says. Curatorship is what the children are under. Parents' patron is that, my lord.
What is her anxiety all the time? No, it is not this is a high court. You tell your advocate, your instructing counsel to whatever you want to tell him. Not, unless and until court asks you to speak, you should not.
Lord, what I gather, my lord, is that, my lord, the husband has psychiatric issue. He has aggression issues, which, my lord, is now slowly, my lord, the child is realizing. And, my lord, the father comes to the child, my lord, and start talking about this case and that case, why your mother is doing this, why your mother is doing that. Lord, these are things which are affecting, Lord, the child. That is the only reason, Lord.
Mother never speaks about the case.
He did not know me.
The child has been brought to court, but not with.
Yeah, we had to.
Without an order of your lordship, and the child is being made to stand in court and listen to these things.
I had to bring because, Lord, my own submission would not have been accepted. Lord, I am saying, Lord, your lordship may talk to the child without both the husband and father.
No. This court is specifically saying none of the parties should come to this court unless and until their presence is asked by the court. Because we have nothing to do with them. And making them sit in the court from morning to evening is also not right. Whenever the court feels
Lord,
that
I would not have advised this, my lord, if I did not feel that it was necessary.
No, court would give a date for that day,
No, but
convenient to the child. Court will interact them in the evening so that he can go to his school and come back. No, something which is really not good for him. Why should he be here? Why should he listen to what all happening in the court? And why should he unnecessarily,
Correct, my lord. I agree, my lord. I would not have wanted this. Except, my lord, I did not have an answer to this, my lord, that all the time he's keeping the phone in the pocket and recording everything.
Lord, I made the submission only once on the first day the video was recorded. Thereafter, there's absolutely
What we do
and kindly see, this is not the only occasion.
No.
Justice Krishna Dixit also noticed all this.
No, we are not on a debate like who is wrong, who is right. No, what is to be done is the question. So, something has to be done. how it has to be done, she will tell. She cannot say this can't happen like this.
I
So
totally
how-
bow down.
How, like, point number one, now, if the father is, children are alone with the father, any third party should be present to see all this, then we will do that. We'll appoint
Your
somebody
lordship
to
said
monitor it.
she should not be there. She has not been there.
Not she. No, her apprehension is, so father has some psychological issues. If the boy is left with the father alone or whatever it is, that she is anticipating something. So for that, there is a remedy for everything. There is a solution for that also. For that, we'll appoint some third person, whoever it is suggested, and he will, whenever the child is with them, he'll monitor. He'll monitor that. But the solution to that is not to say
No,
that.
no, I'm not saying
father
that.
will
Lord,
not.
Lord, as an officer of the court, Lord, I will not say
I'm,
such a thing.
like, the
Lord,
court
Lord,
understands your,
Lord, we also, Lord, we are here to assist your lordship to do justice, not take sides of one party.
yes,
Therefore, Lord, I am saying, Lord, if this weekend, Lord, your lordship may not pass any order. If the grandparents want to meet, let them come as is the situation with the father. Let them come with the father. Let them meet this weekend, Lord. Lord, meanwhile, let him file the documents, and our documents will also be on record. Otherwise, your lordship may take it up
We'll
after
have
2
this
days.
matter on 29th. We'll have this matter on 29th. By the time both of you place everything on record, let there not be any kind of, like,
Suppression, absolutely.
everything should be placed on
Absolutely.
record. And basing on that, we'll pass orders.
I'm a salaried employee, there can't be any separation.
Yes. What are they, he was talking about,
Cost to company.
cost to company.
Yes, no,
That
I
will
will
fine.
place my employment contract, cost to company, what bonus I've received, all salary certificate for the last 12 months.
Yes, please do that.
But let them also file their affidavit of assets and liabilities.
Yes,
But this
both the
weekend-
parties shall file their respective statement of assets and liabilities along with an affidavit, and the father has to
Do you have any proof?
specifically file.
He's been taken.
What is that cost to?
Cost
Cost to
to
company.
company
Cost
also
to
is part of it, yes.
company shall be placed before this court. In this weekend, as ordered by this court on the last occasion, the father along with the grandparents.
Not for
can-
4 hours,
Oh,
my parents may not have.
Waiting in
the-
fear, you
Keep
should
them-
read
Please,
document
sir.
number 11, 40 to 41.
Order,
What is it?
order sheet.
During those times.
Then. Yes. We will remove it.
Can exercise a station.
Saturday and Sunday.
On Saturday and Sunday, that is 24th and 25th of August, between 3 PM to 7 PM in the clubhouse. Same, the other conditions as it is,
May I make this request, Manoj, since
2
my,
and 3 as it is. 2 and 3, post this matter on 29th of August.
may I make this request? Since my parents are also going to be there, Manoj, their allegation is that I'm suffering from psychological disorder. My parents are also going to be there. Can I take them out at 3 o'clock and drop them at 7 o'clock? I will not
Not
take them
this
home,
weekend,
Manoj, but
Lord.
I stay there.
After next week, Lord, your lordship.
We'll pass suitable orders. All the while you're waiting,
Yes, Lord.
wait for a week.
Very good.
And senior counsel, please instruct her.
Yes,
Let her not be
Look,
have.
I understand.
That is like, she alone is not the one who is facing it. Yes,
Sale number 7. Venkatesh Somareddy. For petitioner.
Appearing for the petition, your lordship, in the connected matter, 7.1, we undertake to,
Sorry. First petition. I represent as a respondent, I should file wakalat, I take notice. Take notice on behalf of the respondent. Insofar as I also filed a writ petition, second writ petition. So far as that writ petition is concerned.
we undertake to file wakalat.
Petition will be direct.
so then both of you can argue.
I should file my
Copies,
wakalat.
copy needs to be,
What copy?
7.1,
In,
your lordship.
in WP number 21034 of 2024, Mr. Sachin BS takes notice on behalf of the respondents. And in 8425 of 2024, Mr. Venkatesh Somareddy takes notice. Correct?
Please,
Takes notice on behalf of respondent, pose this matter when?
Any date, my lord.
Pose this matter on 2nd September?
please.
Yes. Yes.
Sale number 8 for admission. C. Shankar Reddy for appellant. Venkatrami Reddy, for respondent.
I pray for respondent number 2, my lord. Before I could proceed, my lord, I would like to file objection.
Which is this case?
My lord, your lordship, my lord, was pleased to hear us, my lord, at an earlier point of time. May I draw your lordship's kind attention to the order sheet dated 1/8/2024. Sir. At that particular point of time, my lord, this honorable court noticed was heard on merits, my lord, in the absence of one of the respondents.
No, it is served.
It has been served and represented by an advocate. And
You-
your
you
lordship has recorded, my lord, what is the case of both the parties.
I am for the R1, my lord. I am for the respondent number 2, my lordship.
I think on the last occasion also you were and he was present.
No, this is the first time I'm coming for this case, my lord.
Oh,
On
you
the
were present
on
on
the
the
last date of
occasion.
hearing, my lord, my learned friend colleague, my lord, sought for time to file objection.
Hmm.
It was at that instance, my lord, the matter came to be posted to today.
Already my arguments was all concluded, my lord. At that point of time.
No, your
No.
arguments are not included, but I heard you also.
May I proceed with my argument, my lord?
1 minute. No, that day the court said not to alienate cannot be granted. And oh,
There were two applications that came to be filed before the trial court, my lord. This is a suit for declaration of title and for the relief of permanent injunction. My case is, my lord, that I had purchased the property under registered sale deed and traced back the, my lord, my predecessors in title.
that I've read.
At that particular point of time, my lord, when the matter was heard on merits, my lord, it was not noticed that one of the respondent was not served. Subsequently, I brought to the notice of this honorable court that matter could not be disposed of on merits. Thereafter, I requested this honorable court to consider the pending application before
Please
this
come
court.
to the order now. Impugned order.
Now, the impugned order your lordships can find at page 17, my lord.
17.
And the relevant, my lord, observation that this honorable court may take note of is at paragraph number 14. That would be page 28, my lord.
You appear for defendant number
3, my lord.
3. You are the contesting defendant.
Yes, I am.
My lord, there is a triangular fight in respect of the property in question.
No, defendant number 3 had also purchased the property.
He claims that he is in possession of the property under a memorandum of understanding.
Hmm.
No,
And wha-
party,
And what about, 1 minute, I'll come to. What about the other?
Other party, my lord, claims that he has purchased a larger
Defendant
extent. My lord, he is defendant number 2.
2 and 3.
2 and
What
3.
happened to 1? 1 is not necessary, but.
One, my lord, is the mother of second defendant who
Third.
died.
Who died?
Therefore, my lord, the suit can continue to only as against defendant number 2 and 3.
Yes.
Both 2 and 3 may not file return statement. I may not refer to a particular site and say, this particular site has been purchased by me. Even as on today, revenue records in the BBMP stands in my name. I continue pay tax. Encumbrance record discloses may not that I am the owner of the property in question. Other side, may not the second defendant would contend that he has purchased a larger extent of survey number in the very same in the same property, and he relies on RTC extracts. This honorable court noticed, my lord, that after the property coming within the jurisdiction of BBMP, revenue records, my lord, would be of no consequence. It is a BBMP records, my lord, which should be looked into.
GPA holder executed memorandum of understanding on 15/3/2021 in favor of defendant number 3. Ever since the purchase. No, you say about a memorandum of understanding, again about a purchase. What is that?
No, purchase my vendors.
Your vendors have purchased.
My
the
vendor,
property.
I'll just come on to that, my lordship. I've given the documents which is placed before the lord, my lordship.
Give that.
Synopsis wise I have produced, my lordship.
Hmm.
Page number 1.
Hmm.
11/3/1944, the existence of property came into picture, my lordship. Then Rahmatsal sold the property to JB Writer.
No, here, is there any dispute with regard to identity of the property, or both of you are claiming the same property?
There is a dispute.
My lord,
The
there is
dispute
a
regarding
there is
my
a
lord,
dispute,
the
my lord.
physical
defendants-
identity of the property claiming by
But,
the plaintiffs.
But on
lord,
documents,
I
one
just-
minute, but on documents, the number shows different.
my lord,
No, my lord.
they give
No,
the
they
survey
have
number
purchased in house list
and
khata
give a
number.
larger extent in terms of guntas. Mine is, my lord, a converted property which shows in terms of square feet. Revenue records, my lord, as it stands in the BBMP is in my name.
From which year?
Not right from the date of purchase, 2004. My purchase, my lord, is of the year 2004.
His name is not there in the revenue records.
They
I mean,
rely on
records,
RTC,
it's not.
RTC extracts, my lord, earlier RTC extracts, which was earlier, before conversion, my lord, it was a survey number. Those records they rely on to say, the RTC records continue to stand in their name.
That is pertaining
And
to.
they, my lord, they give a different description of the property in the return statement, and they say return statement scheduled property. Mine is a plain scheduled property. Plain scheduled property, my lord, is a residential site, where is the, my lord, the compound wall was there.
Even you purchased it as a residential site in 2004.
2004, it was converted earlier. Conversion orders were also produced before the
So
court.
according to them, it is a agriculture land.
Lord, they claim it is
my lordship
agriculture
see,
land.
at
They claim
page
it is
number-
agriculture land. They
One
claim,
thing,
My
let
lordship-
him complete, then
Please,
you can
please,
submit.
my
Yes.
My lordship would see, I have at page number 34, my lordship.
So what is this memorandum of understanding that I am not able to understand?
No, I've ventured into agreement of sale to purchase the property, develop the property, my lordship. From the, my
You have a
vendor.
registered GPA.
I'm a vendor, from a vendor. I'll just come on to that, my lordship. Page number 34, my lordship.
No, come to this events,
Yes, my lordship.
chronology of events.
Yes, my lordship. First is the identity of the property, how, from whom they have purchased. Second one is when Rahmatullah sold the property to JM Writer. JM Writer sold to A Bose. Till here, no problem, my lordship. A Bose, see, expired in 27/7/2087. That is the death certificate I'm producing before the lordship. So they claim to be A Bose has executed a GPA in favor of their vendors in 1993. When a person is expired in 1987, how can a person be execute a GPA? That document I placed before the lordship at page number 34, my lordship.
No, if that is the case.
Then, my lordship.
1 minute, if that's the case. Now, if an order of not to alienate is granted, what is the difference? No, you,
My lordship, the property, my extent is larger extent, my lordship. This is only confined to a smaller extent. 7,000 square feet.
what is there in that 7,000 square feet?
It's empty land, my lordship.
Then don't alienate as far as that 7,000 is
No,
concerned.
my lordship, I have to develop the property, my lordship, because their title is totally different. He has purchased the property and house list number. Not in survey number, not even single place he has mentioned about the survey number of the property. From how he has purchased, which survey number he has purchased, just blankly he has put as house list number so and so out of this property. And apart from the, my lordship, in event of death of the owner, a GPA has been created on the based on concluded GPA, he claims to be the owner of the property. There are 3 subsequent sale deeds after that. I am paying tax from 2001, my lordship.
Come to the plaint, where did she say so? About this boss executing a GPA?
Plaint,
It's
my lordship.
narrated in the impugn order itself.
No, let's go to the plaint.
Plaint, my lordship.
Yes.
My lordship could see paragraph number 6, my lordship, of the plaint. The further plaintiff submits that Srimati A. Bose executed registered GPA dated 6/3/1992 in favor of Sri Ravi Purvankara and Major Trapuran in respect of property number 136/74/6 portion of old number 56/3 and 27 situated in Whitefield, my lordship. It is nowhere it is confined to survey. Nowhere it is confined to a conversion order has been obtained on that property. Now, my lordship, coming on to next to this thing, he mentions that east to west 62.2 and divided by 2 and south 119 and plus 111 divided by 2, measuring all 7,130 guntas. Then, my lordship, authorized to sell by way of
Where is that certificate to show that she died on 27/7/1987?
That's it, wait, my lordship.
Where is that?
34, page number 34.
30?
34
Four of your.
Which one I have filed, my lordship? 34.
Have you seen this document?
Not your lordship, just now I have been handed over. Your lordship may kindly refer to the.
I'm looking at your plaint. Come to para number 6 of the plaint.
Please.
So that's what is the source of title?
Not even earlier to that. Under the registered sale deed of 1965, she purchased the property is not in dispute. Their only claim is that in the year 1987, she died. Therefore, she could not have executed a registered general power of attorney in the year 1992. Your lordships may kindly refer to the document that they have produced before the court.
Come to page number, this document number 6. That is the death certificate issued.
Your lordships could see the husband's name. Husband's name in that particular document. Your lordships could see, my lord, A. Bose alias Arati Bose, female, wife of J.C. Bose. And your lordships may kindly see the sale deed that the registered general power of attorney that has been executed and it is produced before this honorable court. Your lordships would notice that the husband's name is not A. Bose. Your lordships would notice that it is R. Bose. It's a different lady, my lord, this particular document pertains to. Now they want to confuse that particular husband's name and intend to bring it to the notice of this honorable court, my lord. It's a registered document. She has appeared before the sub-registrar. If it is an unregistered document, my lord, a third party would have gone there and created a document. Therefore, if your lordship is referring to the registered.
This one assumes some significance in the suit, the death certificate. Whether it is the death certificate of that lady or not, that is the issue.
Therefore, property remains to be remain intact, my lord. Now, what they are trying to do, my lord, is trying to, my lord, trespass.
Your source of title it can't be looked into at this point of time when she died in 1987 and according to you, it's a 1994 document.
Prima facie, if the details of the death certificate tallies with the document, my lord, which has been executed by her during her lifetime. My
The
lord,
whole issue here is she has not executed.
she has executed the general power of attorney.
Their case is that she's not there, she's not executed.
Lord-
So no, we don't have to look at it. Now, please come to your documents wherein you mention about that Bose.
The document itself, my lord, is placed on record as document number
She
3.
have sold the said property in favor of Srimati A. Bose. Property is sold to her under registered sale deed dated 17/12/1965. Where is that?
That is, my lord, is before this honorable court. My lord, the typed copy is also produced. It is at page 17. 17/12/1965.
From page 12.
17/12.
Not page 12, your lordship could see the certified copy. And the typed copy, my lord, is at page 17.
In which papers?
Not in the documents that are placed on record on
When I have
30th,
produced, my lordship, can be
30th,
which one I have
July.
produced also can be ascertained in page number 31, my lordship.
Page number?
31 and 33. No, my lordship, can be ascertained 25, my lordship. 25, 29, 25, 29.
My lord, I have produced the typed copy for this honorable court. My lord, it will be easier for this court to read.
Which date? Please tell the court.
37/2024, a list of documents, my lord, have been placed on record.
There is nothing like 37.
Titled as list of documents.
37, yes.
37.
Hmm.
Your lordships may kindly turn to page number 17. My lord, this is the
Seven.
17. This is the typed copy of the registered sale deed dated 17/12/1965.
Hmm.
The next document that this honorable court
Oh.
may,
My lord,
We'll read at page 18.
the one more observation I would like to bring to the lord's notice. The GPA, which is at page number 32, can be ascertained before going into deep on that, my lordship.
32 of your papers.
32 of
Your papers.
before the trial court, what he has produced a document.
the same documents
GPA.
have been produced before the court.
GPA.
That is in which page
Page
number?
which one, sir? GPA.
My lord,
The GPA is here.
PA is at page 22 of the documents produced by the appellant.
Hmm.
22.
Page number 22. It
that
starts
would
from
be
page
document number 3, my lord. Document number 3 at page 22.
GPA is by Mrs. A.
A
Bose.
Bose
Bose,
in
yes,
favor
madam.
of Purvanka.
I'll just read the contents of the GPA, my lordship.
A. Bose, wife of,
A. Bose, aged about 65, wife of late R. Bose, residing permanently address residing at 16/A, Neran Sankar Road, Calcutta 7008, my lordship. Compare this with my document produced in 34, my lordship.
Death certificate.
Death certificate.
death certificate, my lord, is at page 34. There your lordships could see, my lord.
Yes.
The husband's name is J.C. Bose,
No,
not R.
place
Bose.
of death and other details are also.
That is also, my
there.
lord, 121.
Hmm.
121, it does not tally with the present one.
I'm coming on to that, my lordship. Now, my lordship, second address presently at 104, Sophia Choice, number St. Mark's Road. In favor of Ravi Purankra, son of so and so, 104, Sophia Choice, number 7, St. Mark's Road, Bangalore. Then third person, Tarpur.
So where are you reading all this?
Lord,
GPA
my learned
executed
friend,
by the
my lord,
A Bose.
is trying to compare page number 22 of my paper book with the death certificate.
Hmm.
Page number 22, my lord, your lordships could see the details of A. Bose.
Yes.
She is shown to be wife of R. Bose. And she is said to be resident of 16/A, Naran Sarkar Road, Calcutta. If your lordships were to refer to this particular state,
I'll just come on to that.
death certificate, it's a different address, different husband's name. Now they want to say this particular lady is the very same lady. Neither the address nor the husband's name tallies.
Yes.
My lord, as per the death certificate and the document and person are the same, my lordship.
Oh, please tell the court.
The address in the death certificate is tallying with the address mentioned in the sale deed of A. Bose. That is a number 121 Central Avenue, Calcutta 07. That could be seen, my lordship.
I'm looking at the GPA.
No, my lordship, 17, page number 17 of documents produced by them, my lordship.
What is it?
That is a sale copy.
Sale
type
deed
copy.
is admitted by them, my lord.
Let in the sale deed, we will see. Yes,
In the
Sale deed is not
type copy, my
disputed. Sale deed,
lord. Okay.
we'll see, we'll see.
Compare with page number 34, my lordship, which I have produced.
You're completely confusing
No,
the
my lordship,
court.
type
Which
copy
one?
of the sale deed.
I'm
which is-
looking at the sale
my lord.
deed. Which
And
page
that's
of the sale deed?
Yes, the sale deed, page number. Page number 17, my lordship.
Yes, I'm looking at 17.
A. Bose, number 121, Central Avenue, Calcutta 7.
Where do you get that?
The middle of the line, my lordship, here.
Mrs. A. Bose,
A. Bose, number 121,
121 Central Avenue, Calcutta 7.
and compare with my death certificate, my lordship. Same address.
not, this document is of the year 1965. The next document that your lordships can see, my lord, page 22, is the general power of attorney that she has executed during the year 1992. 1992, your lordships could see neither the husband's name nor the place of residence where she is supposed to have died do not tally. And if husband's name, my lord, does not tally, your lordships may kindly refer to page 20, document number 3, page 22, my lord.
Clear sale itself.
This is another registered document, my lord, where she has appeared before the
That
sub-registrar.
is the whole dispute now, whether she appeared or not, whether she was there or not.
My lord,
No, that is the
if
issue
the
that the
death
court has to
certificate,
see
my lord,
now.
if the death certificate discloses the correct name of the husband, it is a different issue, my lord.
No, the address is same.
My lord, it is showing as R. Bose.
According to you, like, what is the age of the lady by that time? Date of death is 27/7/1987. I think it's not a case where the court will interfere with this, that the trial court decided.
My lord, your lordship may kindly, my lord, protect the interest of both the parties. My lord, an order of status, my lord, so that the property remains intact. Now, my lord, with all these documents, my lord, we are fighting.
That according in the, now, at best, or the only thing that this court can do is, if you want to adduce evidence, anything for the
Trial is
interim.
required, because there is a serious dispute regarding the
Interim
identity of the
One
property.
minute, for interim injunction, you want any document, or if you want to prove before the court, to say that this certificate is not what,
Please.
then you can do it before the trial court. But this court will not grant any.
My lord, your lordship may kindly permit me to place because these the person who claims to be my lord, claiming rights under a memorandum of understanding, and he opposes both the parties. He says he has got a memorandum of understanding, therefore he is in possession of the property. He goes there near the property.
No, it is not defendant's case what we have to look at. When you're seeking injunction, you have to get it on the strength of your case.
My lord, I do admit, my lord, if your lordships were to see the trial court's order, nothing of this sort is discussed. They would only say there are a set of documents that can't be done at this particular point of time.
Anyhow, it is now before the court. The court can't shut its eyes to all this.
My lord, if your lordships, my lord, is permitting me to, my lord, to place evidence regarding this particular document and to indicate, my lord, that this particular death certificate does not pertain to the one, my lord, who has executed a general power of attorney during the year 1992, that I may be permitted to place on.
At the request of learned counsel for the appellant, post this matter of 2 weeks, that is on 12th of September. The learned counsel submits, according to the learned counsel for the defendant, one Mrs. A. Bose, who has executed the GPA in the year 1993, according to the plaintiff, is no more as she died in the year
1992.
1992. It is not, it is submitted that the said Mrs. Bose died in the year on 27/7/1987. Learned counsel for the appellant seeks time to place some documents before the court accordingly. Adjourned. Yes. Learn counsel for the first respondent, first respondent, who is the second defendant in the suit.
I'm third defendant, but placed as respondent number 2 here.
Third defendant, who is respondent number 2 herein, had filed his statement of objections. Yes, next.
Cell number 9. Raju,
I
yes.
said, what is the date?
12/9.
10/9.
12/12.
Much obliged.
Yes, next.
9. Raju, yes, for appellant. Manjunath.
For the counsel for the appellant.
Petition, they have not furnished the index copy to know the page number which they are referring. And they have not furnished any annexes. Only petition copy, appeal petition copy they have sent. In fact, I am ready to address my argument. I want the index and the annex. Okay, next.
Entire file ಕೊಟ್ಟಿದ್ದೀವಿ.
The postal ಬಂದಿದೆ ಇಷ್ಟೇ.
So,
We'll serve, my lords. No difficulty.
then counsel.
My lords, challenging that, my lords, the gift
Suit is for declaration
Suit is
and
for-
injunction.
and injunction. my lords.
You are the plaintiff.
Lords, I am the plaintiff. Lords, the facts leading to, my lords, the case, my lords, is that property measuring, my lords, the land measuring 4 acres, 24 guntas, lords, in a particular survey number 67, lords, was belonging to, my lords, one Mr. Bangera. Lords, he sold the property, lords, in the year 1996, lords. Lords, few dates, my lords, would be,
Have you
lords,
stated so in your synopsis?
lords, I have stated so, my lords.
Please come to that.
Yes.
See that.
Lords, these dates, my lords, are not found in the synopsis, my lords. That is why,
You have it?
lords, I have my own notes, my lords.
Have a synopsis and give the court, so it will be easy.
Yes,
Soon,
lords.
some other day.
Some other day.
Pose this matter on 3rd September,
4th or 2nd.
4th September. By the time the learned counsel for the petitioner, for the appellant shall file the synopsis.
Right. Lords, there is an interim order, my lords.
Interim order earlier granted is extended till then.
Great.
Cell number 10. Rudra Papi for petitioner. Rashekar K.
My lord, in the first matter, my lord, there are two revision petitions, my lord. First matter, the revision petition filed by the wife, my lord.
Second is by the
Seeking-
husband.
Seeking
What is the amount granted?
6,000, my lord. Earlier it was 3,000 only, my lord. Subsequently, after seeking enhancement, my lord, 6,000.
No, it is enhanced to 6,000.
Please, my
To
lord.
the wife or to the child also?
No, my lord, only for wife.
Wife. What is the husband doing?
Husband was the principal, my lord, in the Women's College Ballari, Government Women's College Ballari, my lord.
How much is earning?
My lord, now 53,000, my lord.
Retired.
After retirement, he is getting a pension of 53,000. Earlier, my lord, he was getting 1 lakh, my lord. At the time of working.
What is the wife? What is her qualification?
My lord, wife is having a degree qualification, but my lord, she is jobless, my lord. She is not getting any income.
What is her age?
Lord, age is 48 age, my lord, 48 years, my lord.
When are they separated?
In the year 2011, my lord.
She
10, my lord.
She is the second wife of the respondent. Earlier, she took the divorce by mutual consent. Later, she married this second respondent.
petitioner. Then the my lord, during the lifetime of then
Both
the-
were,
for her husband
second
also, after the death of her first wife, he got this lady. He got the second marriage. And for the first wife, he has 2 children. For her, prior to the marriage, but after the obtaining the degree of the divorce from the family court, my lord, she got the second marriage. His husband degree. Then in the year 2010, she she filed a 125 petition under section
Which year, 2000?
2010.
10.
That is in Kannada, my lord. Kindly peruse.
What happened to this MC?
MC, she, see, husband has filed a petition for divorce, then the same is allowed. Now she is not she is the divorced wife. And she filed a petition for restitution of conjugal rights under section 9 of the act that came to be dismissed.
And while allowing her petition, permanent alimony was not granted.
Permanent alimony was not granted.
Granted, subject
Why?
to-
Because, my lord, she is a BA graduate, and also prior to that, my lord, she had one female child, my lord. And permanent alimony was not. Why? Because she filed a petition for claiming maintenance under section 125 of the CRPC that came to be allowed in the year prior to the filing of.
What is your age?
Now he is retired principal, about 65 years. Pension payment order also, I may be.
She is 40?
She, as on the date of the filing, she was 40, that
48.
last title indicates that, my lord.
48, my lord, now.
48 now. 65 years in the RW1, in criminal miscellaneous number 172 of 2004.
She is 48 years old. He is 65 years old. You want maintenance from him?
Besides, my lord.
Having, my lord,
Some reason. What?
yeah, he is having agriculture income, rented income. He has not.
All one aspect.
Besides, madam, he is suffering from heart ailments. He took treatment in Jaideva Institute of Cardiology, my lord. He was admitted, and besides.
The court speaks about a able-bodied man. No, you're an able-bodied woman. He is not. Isn't it?
Not, I do agree, my lord, but he is getting the income, my lord, that that income
No.
to be
Why
shared with
You're
the.
separated in 2011. We are in 2022. You are educated, 48 years old. You don't work and you ask for maintenance from a 65-year-old man who is suffering with different ailments. How is it right on her part?
My lord, she is the jobless lady, my lord.
Why?
My lord, nobody can give this job, my lord, at this age, my lord, 48 years, my lord.
What job she wants that nobody can give? Please don't tell the court. If somebody wants to live there, have their own earning that you don't get. You say that I want only that job that you might not get. But anybody can get a job with for her requirement. What that you are seeking, the court has granted 6,000. What with 6,000 you can live your life?
As per my knowledge, Mela, she is working in a pharmaceutical company, but to that effect, no document has been produced, which is an admitted fact. He tried to produce certain documents, so he went there to give certain documents. They have denied, Mela. As per the records and in the cross-examination also, it was asked that she is working in a.
So for example, that pension amount can be, you can attach the pension amount.
My lord, we are not seeking much amount, my lord, only.
No,
my
I'm
lord,
just asking you a legal question. For example, he will not comply, he is not complying with the order. What amount he has is a pension amount. No, you can attach that amount. I'm saying about the next step.
Please, my lord, as per the order of the court, my lord, he has to pay, my lord. And
He has
thereafter,
to pay,
my
no,
lord, otherwise,
I'm
my
not
lord,
on that point. No, for
I got the
example,
point, my lord,
if there is any
if we fail to
default,
pay that, my lord, we will have
if
to.
there is any default,
Please, my lord.
then you have to file an EP. Now, what you want to attach is his pension.
Pension and other income also there, my lord. We have produced sufficient documents before the trial
No,
court.
this is not the
And, my
case
lord,
where the
my
court
lord,
can accept that you want maintenance from a
my
65-year-old
lord, we
man.
have filed the petition for restitution of conjugal rights and they have filed the petition for divorce. Thereafter, my lord, we have challenged the same, my lord. The interim order has been granted by the division bench of the Sonapur court, my lord, of the divorce petition, on the divorce petition, my lord. A stay order has been granted. on 18/8/2021, my lord.
When is the divorce decree granted?
2021 only, my lord.
Hmm?
2021, my lord.
When is it coming up for hearing?
Certified copy of the judgment of decree passed by the lower court.
What stay granted by the court?
My lord, in the division bench, my lord, the divorce decree has been stayed, my lord. Stay order has been granted by the division bench.
So it is stay of all for that is, you shouldn't get married again.
Yes.
That's an order.
At the age of 65 years.
My lord,
Not going to-
she is trying to
Can't afford
rejoin,
to
my
have
lord,
one
she
more
is trying to
maintenance case.
rejoin the husband, my lord. Now, my lord, what has happened, my lord? She also got one daughter, my lord. She has also married, my lord. Now she is alone, my lord. But she is trying to rejoin the husband. He is not ready to
He has
join
two
with the,
children.
that
He
is
has-
the case, my lord.
He has two
I
children.
better adjourn this matter instead of dismissing it. Pose this matter in November, in the month of November, November 12th.
Obliged.
Bill number 11. Kashina JD for petitioner.
Petitioner, my lords.
Sandesh B.
Lords,
Nadige.
in the connected matter, my lords, I have not received with the copy, my lords. Praise for a short accommodation. my lords.
You take notice on 11.1.
Please, my lords.
Ms. Kashina JD takes notice on behalf of the respondents and the council, and 11.1, the council for the petitioner shall color serve a copy and the council appearing for the respondent. Pose this matter on 18th of September.
Lords, interim order may be continued.
Interim order earlier granted in one of the petition, I think, is extended till the next date of hearing. Yes.
Obliged. Bill number 12.
For respondents, my lords.
Who appears for the petitioner?
My lord, I am told that the matter have been settled and a compromise petition is likely to be moved, my lords. There are some 4 to 5 cases has been filed, my lord. So I have been given to understand by the trial court advocate that the matter has been settled wherein the husband has agreed to give a maintenance of 5 lakhs to the wife and some 22.5 lakhs to the child. So in view of that, they have agreed to withdraw all the cases.
No representation for the petitioner. Pose this matter for dismissal tomorrow. The
Obliged,
counsel for the respondent is present.
Obliged, my lords.
Bill number 13. Manjappa MG for petitioner Rajeshwari.
Lordships, in this case with the petitioner, my lord.
What is the order impugned?
This is at page 55, my lord. Page 55 is the maintenance order. So just before I start on the facts, I'm ready in the matter, my lord. Just before I start on the facts and the other positions of law, I represent the wife, my lord. The husband is in Canada. He's a permanent resident in Canada. He owns various types of businesses and all of that. I'm only saying, without prejudice, my lord, if they can just get into some kind of a settlement.
So what is this impugned order? Then the court will understand what is. the
Impugned
settlement.
order is, the order reads at, my lord, at page
What is the order? You can just tell the
73.
court.
I get a maintenance of 30,000 rupees a month.
Are you
Page
paying?
75.
Are you paying?
He's not paid. He's not paid. I'm the wife.
You are the wife.
They've not paid.
What is you came here for enhancement?
I've come here for enhancement, my lord.
And I have
Two
filed
things.
for the,
So no, he says that is there any scope for settlement?
no, my lord, he is almost near to bankrupt. And all his companies have been winded up. And even that returns shows that zero returns in all the companies, whatever they have named in the petition.
Till now you are not paid anything.
No, my lord, I have not paid any, because my lord, the facts is that first she files one maintenance application before the family court, my lord. Then what she does is she withdraws that application. Then she herself subjects herself to the Canada court and files for the divorce as well as maintenance. Then my client happened to contest the matter and almost 38 lakhs expenses he has incurred in contesting that matter, my lord. Once the petition got dismissed, then the wife comes to India again in the divorce petition. She files a fresh maintenance case And
They, the courts at Canada have granted,
no, my lord, it was dismissed for the reason the husband happened to file a third party audit report wherein all his companies were running under loss, my lord.
mm,
And I have filed my financial details affidavit before the lower court.
why was it dismissed before Canada court?
She didn't participate, even otherwise, my lord, it was on merits.
Who has initiated it? Wife has initiated.
Wife has initiated after withdrawing the maintenance application year. She goes herself subjects to the Canada jurisdiction and files an application, divorce petition along with the maintenance petition. And that got dismissed for the reason she didn't participate. One portion, one answer. The other thing is it was on the merit that the evidence was conducted and also the documents were produced before that court that he is undergoing financial loss. And all the companies, whatever the 4 companies which is mentioned by the petitioner in the petition is all been widened up and there is a
Have you
zero.
questioned this order?
Pardon my
Have you
lord.
questioned this order?
Yes, madam. Even I have questioned that. my
Where
lord.
is that? 13.1.
Yes,
Mm.
madam. That is one.
What
thing.
is the basis for the trial court to grant this much?
My lord, the lower court comes to the conclusion that since there are so many companies in his name.
Page
it is-
73, my lord.
In my petition.
You have
it
not
was-
filed your statement of assets and liabilities before the trial.
I have filed, the wife has not filed mine.
So if you have filed,
Yes,
if
madam.
if the companies are closed and all those details would be there.
I have filed my returns, my lord, where it shows 0 returns. So, my lord, the
No
lower.
documents
court-
has been
the
filed.
Lower.
He has only filed the.
Yes.
The lower court
No,
on the
if you do
assumption.
not, if you don't have any income or your company is running in losses, that you can place before the court. Why all the documents are not filed?
My lord, it is in the recent times, after this orders was also placed before this court, recently it got winded up, my lord. And that is what I am filing this, my lord, all madam.
Have you given him a copy?
Yes.
No, I've just received it. She has not served it.
With regarding to the.
It is submitted. When were they winded up?
It shows 2019 and 2020 and 23 of Kalim Inc., where it shows 0 returns.
You have not filed your bank statements?
Back statement, if it is required, I will file it the recent
It
one,
is
my lord.
required before the trial court. Did you file it?
No, at that point of time, I couldn't secure the bank statement, but I have submitted my tax returns at the time of argument.
Okay, have you filed your statement of assets
should-
and liabilities?
I filed, I have no assets, my lord. Please have.
Trial court.
I filed the affidavit at page 50.
My lord, sorry to interrupt. It is only in the form of an affidavit, not as per the Rajneesh versus Neha.
Please come.
where,
What has happened to this MC?
Lordships, I'll just explain in 5 minutes, my lord. Lordships,
No, what happened to this MC?
this.
Still pending and
Still
then
pending, my lord.
stays
It's not disposed,
granted.
it's stayed
And
and.
in the affidavit.
Stay in this.
Yes,
Yes,
my
my
lord,
lord.
stays granted. And nowhere in the affidavit, she tells that she is
No.
not gainfully
So
employed.
it's your MC and you sought
Lordship, I
suit for
was-
that.
My MC,
Because immediately
Your
got
MC.
my MC.
their divorce petition, I am forced to come to India to service his business interests. Now, just look at page for a moment, my lord. Please have page 80, my lord. Please have page 80.
Yes.
Now, he's got 4 businesses in Canada, all successful businesses. The IVA submission that they've made is that I've just suddenly gone bankrupt just to avoid payment of maintenance or any kind of money to his wife. Now, all his assets are there.
What is the wife doing?
She's not doing anything, my lord, because her mother was aged, suffering from dementia. She was taking care of her.
What's her qualification?
Maybe BA, my lord.
BBA, masters,
BBA.
my lord. And she was working abroad also there.
She was not working.
And-
She was working
And she is
under him.
also-
She was
is
working
also-
under him, my lord. Please have page 80, my lord, just for a moment.
Yeah, she's also
Please, for a moment, for a moment.
shareholder, my lord, in one of the companies.
Please, for a moment. Page 80, my lord.
Yes.
This is a company where he is the founder and CEO of Thalamus Medical Media.
and his name.
We'll ask the trial court to consider all this and you let her file the bank statement.
Yes, ma'am.
You also
Lordships,
file, you
just-
also file your
just
bank
Yes,
For a
statement.
ma'am.
moment, my lord, for a moment, I'll just say this, my lord, please, my lord, because it has reached here after considerable period of time, just for a moment, my lord, page 80. This is a company called Talamus, my lord. Then please have page 81, my lord, additional details. Then he has another company called Clean Inc. in Canada. Then he's got one more company called Bite Bank, which is also another media company. And then he has one more company called Oris Bank. And all these four companies are successful companies related to medical, advertisement, media rights. He marries her. She goes after 6 months. He pressurizes her for dowry. He sends her back here. All the materials is here. And she's not allowed to go back because he doesn't sponsor to his till she gets the dowry. She's not allowed to come back. 3 years, my lord, he changes his address, takes all her things and dumps it. Now, for a moment, my lord, how is she supposed to get back to Canada without the support of the husband? For 4-5 years, she was here. And there is WhatsApp chats repeatedly asking, please take me back, please. Husband saying, I have sponsored this flight tickets. I'm giving you maintenance. Please come back to me. Please take care of yourself. All,
You know,
he's in Canada, my lord.
He's in Canada,
not
but
doing anything.
my lord, now he is almost done and dusted with no income there. And my lord.
File all his bank statements.
Lordship, there's one more
Yes, ma'am.
submission, my lord.
Land counsel for the
that-
respondent.
One more
Please,
submission.
in the
Just
necessary-
please, my lord, just one more submission. Now, I didn't have an alternative to get the maintenance here because he was there. The Canadian Council was engaged on pro bono and the entire engagement got terminated because she was not able to go there. After that, penalty, they imposed a fine on me because I couldn't go there. The Canadian court imposed a penalty on me and terminated.
That's why you couldn't contest the case.
I couldn't contest it. So it's hit under section 13 of the CPC, my lord. Then what they do? They come back here. 1 minute, madam. Please, please.
Dismissed on cost, and
Please.
that cost have challenged in original got rejected. That is being challenged here in the writ petition number
No, do you accept this fact that because you have not sponsored her, she couldn't get back to Canada?
No, my lord. She had all the visa and every support. My lord, she has
Ask him
hired
to produce, my lord.
she has hired the topmost advocate there, and she had happened to meet all the topmost advocates there, wherein I could not avail those.
When is the petition filed?
This
Seeking
was filed, my
maintenance.
lord, the divorce petition was filed in 2015, my lord.
IA for maintenance.
IA for maintenance was filed a little later, my lord.
It was filed on 13/3/21, my lord.
21, my lord.
Right from 2020 till now, both the parties shall place before the court their bank statements as per the law laid down by the apex court in,
Lordships, just
and
one.
also the income tax returns.
Yes, my lord.
One
I'll
submission, my
petition.
lord. I'll just make it like this, my lord. I'll just make one humble submission, my lord. In Canada, it's not like your ROC in India. In Canada, only if the petitioner, that's the husband, he gives specific instructions in writing to the Canadian authorities, company authorities there, registrars, only then they will release data with regards to the profit and loss accounts of the company, audited financials, financial statements, all company
Tell the
data.
court how to get it.
My lord.
I'll file
that
the
is-
necessary application, my lord. I'll file it before the lordships. I'll file it before the lordships, and regarding, my lord, that penalty.
Call for that.
One more submission, my lord. Here, that penalty case was, then they filed an OSR saying that you give me 9 lakhs because penalty has been imposed. They filed an original suit. That got rejected, my lord. That got rejected on the grounds of 13.
Submitted that the petitioner.
Challenge that
Well,
document.
petitioner will come before the court. Petitioner will file necessary application with regard to the the details of the husband's,
I'll file that necessary application asking for discoveries and interrogatories.
post-mortem.
I'll do that. Grateful, my lord.
On 18th of September, by that time, entire material shall be placed before the court.
Okay. Cell number
Any
14.
suppression is there, your client has to. pay
Yes,
for it.
yes, my lord. It is a true fact
No,
that
you,
is.
you send her to India, you don't allow her to come back.
No, my lord, in fact, I have transferred 1 crore to her
Lordships.
account. My one.
Just look at
1
annexure
crore,
G,
1
my lord.
crore.
Look at
One crore.
annexure G, my lord, of how they.
She
what-
is also equally participating in the business and she is asking her own relatives to invest in my business, that they name it as dowry. She herself equally participates and all the documents, whatever they are producing, shows that he is running out of money.
No, she's not interested to take divorce.
She is not, where she files for divorce, here she is contesting.
Yes, Mr. Counsel, she's not interested for a divorce.
Lordships, she's making, that is what I said, my lord, without prejudice.
Settlement is asking about.
Yes,
Yes, my lord. But
they are
please-
honorable.
please
They are
note,
saying, no, I don't
they-
have 1 rupee, I won't give you 1 rupee.
In crores,
And he is-
he had so many companies and all the companies gone to watermelon.
This is a eyewash argument, my lord.
I'll file
Can't be
tax
accepted.
returns. I'll file my tax returns for all those zeros returns,
Can
whatever.
you
it is
first
about.
let him come up with such an application?
Let him come.
Let
my
him
lord.
get the details,
Ah.
then we will pass.
We will, yes, ma'am.
Yes, pose this matter on, give him the date, no? Yes. Yes, next.
For 14, Suresh Ishwarappa Muglaki for petitioner, V.K. Ramesh.
My lord, at
I'm
the,
respondent, my lord. Today only I filed wakalat after obtaining a notes, my lord.
2023 matter, today you filed wakalat.
I have produced my lord
After
address
taking
it,
a motion.
last date, my lord. Entire address of the lower court record. Your
Yes.
lordship has directed me to
Hmm.
produce the same.
Ready?
Today only I filed a wakalat after taking on notice. It is only with respect of the order 6, rule 17, that amendment application that has been filed by the petitioner in the MC case that has been allowed and we are already incorporated as per this file is concerned. Ma'am. So that has been challenged
What is the amendment that is? sought?
regarding cruelty and
May I submit one?
to further.
My lord, on 27/7/2023, they have filed one application under order 7 rule, order 6 rule 17 for incorporating new grounds in the main petition, my lord. After more than 4 years, my lord, they have come up with new grounds. They are only imaginary grounds, my lord. And on that ground, they have filed, my lord. Next date, I was not given opportunity to file objection, my lord.
That you're
Before-
referring to?
My lord,
Where are those documents you're referring to?
I have
Have they
produced-
Yes, it is here.
Yes.
What is it you want to say basing on this?
My lord, your lordship may kindly look at page number 17.
Yes.
Page number 17, date 21/7/2023, my lord. On that date, the petitioner has filed application for incorporating new grounds.
Yes, IA number order 7 rule 11
Yes,
application
my
is
lord.
filed.
And on the next date, my lord, the honorable court regarded that, my lord, allowed the application. I was not given opportunity to file objection, my lord. That is my
So
prayer.
when the court is allowing an application order 7 rule 11, it can't be like this. There should be a reason for that. You should record the reasons.
That is
Without
true.
recording the reasons, how can the court pass such an order?
I will.
That too, that too.
My lord, I was also present on
That
that
too,
date, my
an
lord.
application that is filed after 5 years.
That is true. As
Hmm.
per this thing. I will look into the matter. Your lordship kindly have it.
You cannot look into any of the matter, the order itself, you can't improve the order now.
Because it is before the, see, the thing is before the evidence that has been, application has been filed.
Whatever it is, the court should know. It should be a reasoned order, it's on an IA. No, if he has to.
After
question,
evidence,
he'll
no,
put the
after
court-
evidence. 4 years back, evidence was
Reasoned
recorded,
order.
my lord.
We will set aside this order,
My lord, kind. It may be,
set aside this order. Let
I may be
that
given
application
opportunity.
be considered on merits.
my.
How can there be
Your
an order
lordship
like this?
kindly regarding to pass a reasonable order. It's not
Reasonable order.
reasonable order, because the thing is, I may be permitted to file an application for fresh ground
Yes.
any time regarding order 6 rule 17, but only thing is the
Anytime.
reasonable order has to be passed by.
Yes.
That I too
Much,
agree.
much, much,
That's what, let the court do that exercise now.
much.
That again,
It has to be.
Again,
It
again,
has to
one-
be, no, like, it has to be. No, but when the court after 5 years, when you're coming up and saying that I will amend my grounds, my prayer and everything, Then there
It
should be
should
some
be,
reason.
it should be heard both sides and then.
Then
the
an
reasonable
order should
has
be
to be
passed.
Yes.
Without that, an order is passed. How is it justifiable? The agreed with the order passed, agreed with the order dated 2023, whereby the trial court had allowed an application filed by the wife.
Husband.
You are for wife or
Husband, I appear.
filed by the wife under order 7 rule 11, order
Order
6
6
rule
rule
17 is allowed by the trial court. The husband is before this court. Land counsel for the, who filed MC?
My lord, wife.
MC filed by.
Is submitted that
Me, my-
land counsel for the petitioner, husband submits that wife had filed MC number 346 of 2018 seeking divorce when the, after the evidence has commenced on 25/7/2023, an application is filed under order 7, order 6 rule 17 seeking amendment of the plaint, petition. Then the matter came up on 28/8/2023. On the said day, by order impugned, the court had allowed the petition and without giving any reasons. The court has observed that advocate for the petitioner present, respondent present, but advocate absent. Sufficient opportunity is given. Objection to I number 7 taken as not filed, heard and perused. As a proposed amendment is necessary for fair and complete adjudication of the list. The PW1 has not been cross-examined. The grievance of the respondent can be compensated in terms of money. And accordingly, on cost of 1,000, the amendment is allowed. Land counsel submits that the court cannot pass such an order. No reasonable opportunity is given to the husband to file his husband to file his objections to the said IA. And it is submitted that even otherwise, if the court wants to allow the said application, court has to give reasons and pass the order. Next part. Land counsel appearing for the respondent wife submits that as in spite of an opportunity given to the husband, as he has filed to place his objections, court has allowed the IA filed under order 6 rule 17. And there is no illegality with the said order. As such, the petition is liable to be dismissed. Next, land counsel, having heard the counsel on either side, there is a material non record. The wife who had filed the MC seeking divorce had filed an application under order 6 rule 17 on 25/7/2023. Had filed an application and on that the court had granted permission to the husband to file his objections on 25/7/2023. Matter came upon 28/2/2023. 28/8/2023. On the said day, the trial court has allowed that IA solely on the ground that no objections are filed. When the amendment is sought, after the trial has commenced, and on such application, just because the respondent has not filed his objection, the court cannot, without giving any reasons, cannot pass such an order. The order, an order that is passed without any reason has to be set aside. Accordingly, the writ petition is allowed and the order dated 28/8/2023 is set aside. Set aside, number one. Number two, the respondent, the petitioner husband shall file his objections within 1 week. Within 1 week from today.
Much over.
From today, not from the date of receipt of the order.
May I want minimum 2 or 3 weeks.
Within 2 weeks from today.
Yes, ma'am.
Within 2 weeks from today. And on filing such objections, the court shall decide the IA number 7 on the merits of it, and the order shall be passed on the IA within 2 weeks from there on.
Much.
Till number 15,
My name may be shown.
VK
My
Ramesh.
Your name
may
is
be shown.
not there.
VK Ramesh.
Huh?
PK Ramesha is there.
No, Ramesh is, I have taken an OC one.
For the respondent, what's it?
Him
Take
can-
that name. Here. Next.
Till number 15, MJ Alva.
Yes,
For
I'm
petitioner.
for the petition, my lordship. The petition has filed the above petition by challenging the order of the court below. 27,
What do you want now?
20th 1, 2024.
What do you want now?
We want to interim custody of the children's, my lordship. So already with this court also 3 times interactions with the children.
Please come.
The father of the
Court had interacted with the both mother, father and the children on 18/4/2024. No, on 18/4/2024, this court passed an order directing the mother, father and the children to be present before the court on 23/4/2024. On 24/4/2024, this court has passed the following order extracted. No. On 24/4, don't extract that. On 24/2024, this court had passed an order whereby this court had directed that on every Friday between 11 AM to 1 PM, the mother can meet the children, the CPDO office, Arkalak, Gudu, Taluk, Hassan district, and the father shall see to that the children interacts with the mother and directed the matter to be listed after summer vacation. When the matter came up on 26/2024, on the day, the father is absent and the mother is present before the court. Counsel informed the court that the counsel submits that he has already informed the husband about the hearing today. It is submitted by the mother that on all the dates of the visitation, the children were kept in the car by closing the glasses and just she made to stand there looking at them. On all the days of visitation, this has happened. This court in the earlier order has observed that about the father tutoring, the manner in which the kids are not responding to the mother. The court observed that the absence of the father shows that he has no respect towards orders of the court. Then directed the matter to be listed on 8/7/2024. Thereafter, on 15/7/2024, at the request of the land counsel, the respondent, the matter was directed to be listed on 24/7/2024. Again, on 24/7/24, also the matter was adjourned. On 31/7/2024, it is submitted by the counsel for the husband that he couldn't speak to the client over phone and he has addressed a letter. And if no instructions are received, he wants to retire from the case. Then on 14/8/2024, a memo of retirement is filed before the court. And the same is ordered. And the court had directed to delete the name of the counsel and print the name of the party in the cause list. Today the matter is listed. There is no representation on behalf of the respondent. And the respondent, land counsel submits that in spite of an order passed by the court, the mother is not able to see the children. The children, and when this court had interaction with the children, the court could see that the father on his tutoring, they're not even looking at they've not even looked at the mother. In spite of the mother was continuously pleading the kids even to look at her. And they were very much reluctant. And when there appears to be no no reason for them to do that, not to talk with the mother. The court is when the court has specifically asked them, they didn't give any reason why they do not want to talk to the mother. It all appears that But there are differences between the father and the mother. The father is completely is alienating the children from the mother. The mother was continuously coming to the court seeking a relief of custody of the children. Considering what was the order of the trial court?
The trial court is rejecting the immediate custody of the children, and the other hand, passing the order of visitation, right, in twice in a month. First Saturday and third Saturday, afternoon 2 to
The
5.
trial court had passed an order granting visitation on
On first Saturday of every month and third Saturday of every month,
first Saturday and third Saturday of every month.
afternoon 2 to 5 p.m.
Agreed thereby they are before this court. In the considered opinion of this court, this is a case of complete parental alienation, which cannot be permitted. And the children require the affection of the mother. And the father cannot, he cannot be permitted to take, the father cannot behave in such a manner which is detrimental to the welfare of the children. The conduct of the father all through shows that he has no respect to the court and to has no respect to the court and to the orders passed by the court. Hence, in the considered opinion of this court, this is a fit case where the custody has to be shifted to the mother. Accordingly, the mother is entitled to have the interim custody of the children pending further orders before the orders in the what is the number? GNWC number 27 of
In 27 of 2023.
2023. Accordingly, petition is
Last date, a report of the CDP officer also filed.
Hmm.
In all 13 visiting rights.
in
is
the
not
order.
keeping present
The
children.
petitioner wife has filed before this court the report of the
Out of 13 dates, he visited.
the report of the Child Development Officer, Taluk Panchayat, where the visitation was exercised. Where it shows that on 7 occasions, the father was absent. And within no time, in a matter of 20 minutes,
Please, 20 minutes.
matter of 20 minutes, 20 to 30 minutes.
In those visitations also,
They
is
left
kept
the
in
place.
the.
Yes, yes, I knew you have an order. Yes,
Please,
next,
please.
disposed of.
Cell number 16. Cell number 16. And Gautam Raghunath.
My lords, a few submissions to make. Your lordships, in fact, on the last date of hearing,
80.
spoken to the respondent mother in chambers and also advised the parties to settle the matter based on the submission that I had made the earlier hearing dates, my lords. I've spoken to the parties, I've spoken to the petitioner. He is willing to settle. He's not stating that he is not willing to settle, my lords. The terms and conditions, my lords, what he feels is, my lords had suggested that let the overnight custody start from 2025 August, which he's not agreeing, my lords, because of the fact that the minor daughter has been in the custody of the mother since 2021, wherein he could not even meet the child until he moved the courts. Unfortunately, that's been the state of affairs in this case.
So he has not seen the child from when to when?
He has not, after 2021, until 2021, the child was with the father.
No, from 2021 to 2024, he has not seen.
He's not seen, my lord.
He is able to see, he's spending time.
My lords, now, my lords, by virtue of the order that came to be modified by the trial court, the first order that was granted by the trial court was 4 hours in a month, my lords. 2 hours on every alternate Saturdays. Then I had moved your lordship's coordinate bench. His lordship said you file a varied application, and his lordships also said that seek for modification there. Then by virtue of modification, I had filed an application seeking overnight custody, everything. My lords, it was not a speaking order. The court said no, 7 hours a month, alternate weekends. The court said not even a reason in respect of why overnight custody is not granted. Whereas then your lordships were grateful enough to modify that order by permitting him to take the child home and drop the child back, which is absolutely all right with. One aspect that he would want to bring it to your lordship's notice is, my lords, in the coordinate bench in the earlier writ petition had issued notice by hand. My lords, I probably would have to stand witness to that because I had to serve the lady in person. My lords, the place where the mother is residing, my lords, ultimately, whatever the places, all of them are human beings. I'm not denying it, my lords, that he feels the atmosphere is congenial because, my lords, the house where she's residing when I'd been to serve, it's not safe. My lords, surrounded by slum, my lords, that's one. They're also human beings. I'm not making any allegations as such. He's a bit worried and concerned because, my lords, a few things have happened. I would not probably want to place those photographs on record, wherein apparently the minor daughter was bitten by a rat. Was bitten by a rat at her residence. These are his concerns. What he in fact suggests is, my lords, she's agreed for a sum of rupees 50 lakhs as alimony, which we also concede to, my lords. What happens is he would want her to at least shift to a better place because of the fact, my lords, I've myself seen the place, my lords. I do not know how to put it across. That being the reason, my lords, his worry is that an overnight custody, of course, my lords, he says, why from August? Why not from summer vacations or the ensuing
Yes.
Dasara or Christmas vacations?
Lordship is coming out with a new proposal, which were not earlier there. So the negotiation was confined to the alimony. That's all. So, and he's very much concerned about his daughter right now. Then make an alternative arrangement for the wife also. Let her be shifted to a new residential area. So since she is an
No, she will shift to a new place where whatever in a better accommodation. What is she paying for that accommodation?
Ma'am, that is,
What is whatever she's paying, she's paying.
that's her own house, her father's own house where she's staying presently. That is the issue here.
It is her grandparents' house. It's
Her grandfather's own house, apparently.
not even her father's house.
No, is she interested to shift if he provides?
No problem.
Let him provide.
He can
Yes,
provide
Your
your
Honor.
lordship. He's
No, you
earning-
cannot, you
apart
cannot,
from-
no, you cannot tell a person that, please, your standard of living should be upgraded. If it should be upgraded, if she has the means, she would, if not, the person who wants it to be upgraded should upgrade it.
Certainly, my lords. I'm not denying that, my lords. He's agreed to pay the alimony, my lords, and he's agreed. All that is bringing it is ultimately my lords. In fact, he has been telling me, which I am not submitting to this honorable court, is he is going a step ahead and he's saying, "You give me the custody, I'll take care of the child. I'll keep her safe." But my lords, like your lordship is aware, that cannot happen. Child deserves love and affection of both the parents. Because that being the reason, my lords, this is what he has come up with, my lords. In fact, there are other aspects, my lord, which he in fact wanted to state it before your lordships, if I'm permitted for him to state it in the open court. No problem, my lords. He has,
You can tell the court, not him.
please. My lords, these are his concerns. The house,
No,
the
for that,
overnight.
what is your reply to that?
My lords,
You
so
find out from him and tell the court.
he says separate accommodation apart from what he's paying as alimony would not be in a position to afford at this point of
Where
time.
from she will get now?
At this point of time is what he states.
So the first proposal with regard to change of the house is something which is not practicable.
Please, my lords.
So which we can't think about it, number one. Then where is the hitch now? Where is the other glitch?
The other glitch is, my lords, the overnight custody, my lords.
What was agreed upon?
Their suggestion, my lords, based on whatever your lordship stated the other day, is that because now he's getting custody, he's getting to take the child home and drop the child back. The lordship said, why don't you start it from the coming August? His, my lord's
So
apprehension.
for example,
Yes.
this court do not grant the custody overnight.
Yes.
And the matter will be going on forever like this. What is the relief he will get? Why
I in
is he
fact
not understanding
put in
it?
my best efforts to in fact make my client understand my lords in this. And
Let him, then we have to pass orders on the merits of it if he's not
but it's
interested.
here, I in fact not even getting into the merits of the matter, my lords, to be very honest, this is a matter which can be closed, which definitely can be settled. The response has been gracious enough before your lordships in chambers, wherein she agreed that he could take the child, only he
Has
and
to be, there has to be an adjustment from both the sides.
please, my lords, please.
Now, what was not happening from 2021 till 2024,
please.
when something is happening, you can't be demanding. These are all the relations, and it's a strained relation.
Because I'll in fact, the house aspect also, I'll restrict myself, my lords. I'll in fact withdraw my submissions in respect of that. My lords, but in respect of overnight, something at least, my lords, because I mean, my lords, conditions that only he and the daughter can travel, the relatives cannot travel. Those are a bit too strict, my lords, because his sister or his mother, I mean his
No, no, that is
father.
not what she said.
No, she had made it very clear, my
No,
lords.
she didn't say that. She was
No,
referring to
he says
something
if
else.
he gets remarried, to which I concede, my lords, that I've already told him. That is if he gets remarried. That is anyways, my lords, might not happen. But my lords, what his problem is that she's putting him on conditions wherein so and so should not appear. He's like, why can't his sister or his father travel along with the child? Means that as far as I remember, means that she said it was only father and
She
daughter.
says so that his brother and his father and sister,
No, not at all, your lordship.
that's not what she said.
Because my lords, on the
They are
last bit
not
of my lords,
put
What she didn't say.
all that she stated was the
Understand what is
remarriage
there.
aspect. I agree, my lords.
The
Your
understand
lordship said-
refers to a third party, not the family members.
Yeah, family members are okay then. My lords, he's absolutely all right with that then.
He never, she never referred to.
Yes.
We have
My
not
only
put any such
some
condition.
I remember that.
some tuning regarding my lords overnight custody would be great, my lords, because
Overnight
my lords,
custody is not
he's paying maintenance, apart from alimony, he's willing to pay the school fees. It is his duty ultimately. I do not deny that, my lords. He's even till date, he's been paying maintenance, no arrears, taking care of the school. My lords, some overnight custody at least, my lords. That is what he as a father would request, my lords, because my lords, we are at your lordship's mercy here. That is all I can submit, my lords, because
We cannot accept that proposal, your lordship, for the time being, because of, we have tried to convey the conditions and other things, but.
He says that your client is living in a pathetic condition. Your client says that his wife, his house is not a hygienic place to live.
Yes.
Which is correct in both the
Because
statements.
his profession is like that one. So we cannot expect a good atmosphere for a girl child of 6 years old. And most of the time he will be traveling. He will be outside Bangalore.
When he is outside Bangalore, why the girl will be there in overnight?
yes.
That's what I,
She won't be.
yes, she won't be. And, and his parents are also aged and they are suffering from alignment.
No, whenever the father is in Bangalore, then only they will exercise.
Yes.
When the father is not in Bangalore, they will not, he cannot exercise.
No,
Yes.
And she
majority of
won't
the
be sent
time,
to, when father is not in town, that time they won't exercise the overnight visitation.
no, majority of the time he will be out of Bangalore only and he is
Then he
into
will
the.
not. If he is majority of the time is out of Bangalore, that time no visitation. That would be the, isn't it? How can when?
My lords, whenever he's not been able to visit, whenever he's been traveling,
We are not
he's
coming.
requested the mother to compensate, she's compensated.
Visitation
That's how
rights, we are not coming in between, your lordship. We are only worried about the overnight custody. That's all.
If it doesn't happen,
Custody with whom?
With
No,
the.
no, she says that he can, the father can take the child out of Bangalore. That time then he'll be having the overnight custody. What will happen to that?
No.
Please tell your client now almost all the clauses or whatever her conditions she said, or no, he is ready to comply with. So let there be a via media for this, and what are the conditions on which she wants this, let her come out. Now what will happen is, no, she'll be fighting this litigation for, he and she will be in the courts.
No, let
Please,
them.
no, because everything is now settled, except that clause. So what is that? Let her come up with her idea.
may I, my lords, may I, my lords. If it doesn't happen today, my lord, it never happens. That's been the norm in all the cases my lords has in fact adjudicated till date. Your lordship is more aware about it. My lords, the problem here is the egos between the parties, like I've already submitted, my lords. My lords, all that is asking is for overnight custody. He's willing to pay. She's
No,
yes,
no,
please,
nothing
please.
is going to change. It will happen. Let her come up. come
My
out
lords,
with,
the order, in
pose
fact,
this matter on 29th, by that time come up
This-
with.
my lords, this weekend,
correct.
I had not sought for the earlier weekend visitation, my lords. I was fair enough in that. It's an alternate weekend. This Sunday, he may be permitted to pick up the child, the same
So and
order, my
so
lords.
on Sunday, that
Not
is
on
20.
Sunday, Saturday.
Huh?
It was,
Saturday.
as per the original order, it was on Saturday.
What is that?
Saturday, she has school, my lords,
Not
traveling.
Saturday.
Saturday, she has school. That is the
On
problem.
25th August, Sunday, the father can exercise a visitation. What was arrangement?
10
last
a.m.
time?
he picks up the child and drops the child at 4 p.m. But my only request here is, if I may be permitted to drop the child at 5:30, because my lords, to go 1.5 hours, to come back 1.5
What
hours,
was the time I asked?
10 a.m. to 4 p.m.
Ah.
May it be from 10 to 6 minutes, please. Please, that time. will be-
Give that.
No, if it is 6 means, it will be extended by another 2 hours. It will
No,
be.
no, it
I
can't,
dropped him,
it
but
should
stop.
be on dot. That I'll record.
He's been dropping on it only once.
The father
And
can.
moreover,
pick up-
her
Huh?
next day classes will also be get affected.
What is that?
If it is on Sunday, taking out the child on Sunday, Monday she will be having schools. class.
But that she has the whole.
You can send the homework, the father will get it
with
done.
her. The father shall pick up the child from the mother's place at 10 a.m. 10 a.m. That's what is
Please,
happening.
please, that's what has been happening.
At 10 a.m. and shall drop her back sharp at 6 p.m. The father shall adhere to the timeline
Please.
and shall adhere to the timeline. By the next date of hearing, mother shall come up with what are the her plan about the overnight custody, and basing on that, then what, have you, have you put it on paper?
I had given one draft and they had reverted with a modified draft. Then your lordships told me to again come up with a modified another draft. But my lords, in the meantime, my client had, in fact, the petitioner told me that these are the issues which he wants to like focus on.
No,
That
you
is
know,
the
again,
difference.
the revised.
That is the issue.
Again, the revised one, send it to them.
I'll in fact,
The
I'll
petition,
send a revised
the
one. and let
counsel
them-
for the petition shall
Please.
send the revised settlement plan to
Petition.
the respondent. Yes.
Instead of 6 o'clock, can it be made as 5 o'clock?
My lords, why are they being so petty, my lords? Please.
5 o'clock shall drop the child.
My
by
lords,
5
my
o'clock.
my issue is, my lords, 1.5 hours to travel, my lords. Please, my lords. If I may request 6, my lords.
Yes, yes.
Hardly
Let's
5
see
kilometers
next time.
from his
Yes,
place,
next.
from his place.
Next matter.
17.
17.
17, Ravi Shankar, CR.
Commissioner,
Yes.
some already as per lordship departed and already
Call.
spoken about the other part.
Hmm?
I already spoken about the other part of the advocate, respondent advocate. And they may settle the matter. That's why one opportunity
They
given.
submitted that there is a likelihood of settlement between the parties. Pose this matter on 10th of September. Yes, next.
And your lordship stay may be extended.
Intermodal earlier granted is extended to the next date of hearing. Yes.
Much obliged.
18. Basavaraj Sappananavar.
My lord, I'm appearing for petitioner, my lord.
Yes.
I'm appearing for petition, my lord. Petition is the response before the trial court, my lord. The respond number 1 has filed a petition under section 125 CRPC.
How much is granted?
20,000 rupees has been granted monthly maintenance towards the son, my lord. I'm prepared to pay rupees 20,000 every month. The problem is that, my lord, my lord may kindly appreciate, the order has been passed in the from the date of the petition. Petition has been filed in the year 2019. That comes to rupees, arrears comes to rupees 11,20,000. As per the direction issued by given by your lordship, I have deposited rupees 4 lakh. My lord, here and after also, I am prepared to pay 20,000. My grievance is that the arrears, the maintenance has been awarded from the date of the petition, that is from the year 2019. I
That
am
is
having.
what, how it is. That is how it is. Your case is not an exception. Arrears would be from the day, the maintenance would be from the date of petition.
Yes,
It relates back to that.
It is my duty. It is my duty, my lord. I will pay the maintenance. My request is that your lordship may kindly dispose of the petition by directing me to deposit to half of the arrears, my lord, because I have already deposited 4 lakh. Now I am going to deposit 1,60,000. That is totally 5,60,000.
How much you have deposited?
4 lakh I have deposited, my lord. And if your
Deposit
lordship
another 2
directs
lakhs. Deposit another 2 lakhs.
yes, my lord, I will deposit.
This court by order dated 21 by order dated 18/7/2024, I directed the father to deposit an amount of rupees 4 lakhs and also continue to pay an amount of rupees 20,000 per month. When counsel for the petition submits that as per the orders passed by this court, he has deposited an amount of rupees 4 lakhs and also continuing to pay an amount of rupees 20,000 towards arrears of maintenance. Another 2 lakhs the petitioner shall deposit within 4 weeks from date of receipt of the copy of the order. Pose this matter. Pose this matter on 4 weeks from now. Today is 22nd. Pose this matter on 23rd September. Yes.
Serial number 19.
No, in that order, no, on such deposit, whatever is the deposited amount, the respondent is at liberty to withdraw.
No, my lord, my submission is, my lord, the respond number, if the respond moron is allowed to withdraw the amount, I may be heard by the trial court, because the reason is that, my lord, my apprehension is that for the welfare of my son, I am depositing the amount. Let it not be misused by the first respondent. This is my apprehension.
Let it's permitted to withdraw the amount. Yes, next.
Serial number 19.
Appear for the petitioner, my lord.
Yes.
My lord, I have deposited, complied with the order. I deposited 45,000 before the trial
Complied with the
court.
order?
Complied with the order. And
Give the order.
on 5/7/2024, I was directed to deposit
The order was
5/7/2024.
pay the maintenance of an amount of 5,000 per month by 5th of every succeeding month.
Please. The arrears for
Rupees
45,000.
45,000 within 6 weeks from the date of receipt. Both are done. Land
45,000.
council submits that by order, as per the order dated 5/7/2024, he has deposited 45,000 and also is continuing to pay 5,000 per month. The respondent is at liberty to withdraw the amount. No representation for the respondents. Pose this matter on 16th of October.
My lord, interim order may kindly be
Interim order earlier granted is extended till then.
Obliged.
Yes, next.
Petitioner,
Order
we
going
kindly
back.
request for the matter to be taken up on 29th, your ladyship.
Your lordship, already the divorce petition is filed by the husband and both of us has consented for a mediation and the mediation is still pending. 29/8 is the next date.
After that, we'll.
She has not appeared on 2 hearings.
Writ petition is pertaining to the maintenance case filed by me, your ladyship. That is a different case that my learned friend is speaking about. The maintenance of rupees.
Anything can be scored out there is what I am mentioning.
You can ask when mediation is
understand,
going
your
on, you
ladyship.
can go there.
We have an 8-year-old daughter, not a single rupee is being paid towards maintenance. His
Correct.
income
Pose
is
this
2 lakh.
matter on 28th,
29th.
it's coming, happening. Pose this matter on September 22nd, it is submitted, it is stated by the counsel for the respondent that on 28th,
29th
29th, the
August.
matter is coming up before the
Mediation.
mediation center. The wife shall also attend the mediation on that day.
Please, your lordship. One request, if I may make, an amount of rupees 20,000 has been ordered. My application was from the year 2022. At least if arrears may be paid pertaining to what has been ordered.
Your lordship, I've heard this matter in earlier writ petitions. And probably the documents with, and also the restraint order was like, your lordship did not interfere. The documents were ordered, asked to, by the petitioner was supposed to return back within 2 weeks. The documents was not returned fully. Even the contempt petition is filed. The passport, she else the passport again, the old passport. She doesn't give the birth certificate of mine.
What's happening?
I don't know what.
Between the wife
There was
and
a direction given to my brother to hand over whatever documents were mentioned by me in an email.
And
has to hand it over.
it is
As per
my
the direction.
apartment.
like a normal person, sir, both of you. What is this? No, you don't like to stay with each other.
It's
You
my
want to-
apartment.
No, you want to take divorce, take divorce. And whatever you want, come up with those settlements,
Proposals.
but not
The
like, I
conditions-
will hold your
I'm not holding any
certificates,
document,
I'll
your
hold
lordship.
your passport.
Nothing is being held. This honorable court passed an order directing us to hand over the documents. It has been handed over.
Let the wife appear before the mediation, we'll see. Yes, next.
Serial number 21. Hearing on IA. Narendra Gowda for petitions. Appellant.
This case, my lord, challenging the order passed by the trial court granting compensation of 20,000 per acre without considering the potentiality of the land. And
2006, sir.
2006.
What is this IA?
I have produced the document, additional document
No, no, delay, there's a delay of 217 days.
in filing the appeal. In filing the appeal. So
Is it
that-
as per the new act, can the delay be condoned?
Please.
Can it be condoned?
Please, Mary, it can be condoned.
How? What is the delay that can be condoned in filing an appeal under the Land Acquisition Act? See that?
Paid comp.
I think that issue is pending before the, what is the delay?
Delay of 217 days.
Not this, sir.
Please.
Is it a new version?
I tried to pay comp.
Which is the provision? Deals with appeals. Huh?
Section child.
Hmm. 70? Hmm. The requiring body or any person agreed by the award passed by the administrator by an authority under section 69 may file an appeal to the High Court within 60 days from the date of award. Provided that the High Court may, if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal within the set period, allow it to be filed within a further period not exceeding 60 days. So now it is 60 days
Let's see.
from the date of award and another 60 days, 120 days.
But this acquisition is of the year 1993.
That is old act.
But repeal and saving. Page number, it's 114. Please come. The IA number 1006, 2006 is filed to condone the delay of all are served.
Please, madam.
To condone the delay of 217 days in filing the appeal. Considering the reasons state, no objections were filed by the respondent. Considering the reasons stated in the accompanying affidavit, the delay of 217 days is condoned. And IA number 1006 is allowed by condoning the delay. Then what is 5 of 23?
5 of 23, my lord.
What is the leave?
Leave, seeking leave of the court to permit the additional to bring the beneficiary and recallment.
Original proceedings.
Because he was not made a party before the trial court.
Who is the beneficiary?
Executive Engineer, Public Work Department, Asan.
To appear.
Please, he is appearing.
To appear
Government.
for them. Yes. IA number 5 of 23 is also allowed. And so is permitted to come on record. Is impleted as respondent number.
As the respondent number 2.
Respondent number 2, and the petitioner shall carry out the necessary amendments to the necessary amendments. Next, IA number 1 of 24.
IA 1 of 24, my lord, I am
Order
relying
41
upon
to
the
27
judgment.
petition.
Please,
That we will consider it during the course of hearing.
please.
IA 1 and 2 are IA 1 of 24 and 2 of 24 will be considered during the course of hearing. Are you ready? Huh?
Next week.
And then be ready. It is 2006 land acquisition. Was this matter on 4th of September. Yes, next.
Cell number 22.
I am for the appellate, my lord.
Have you filed your objections for this delay? Delay. What you will file? It is coming up every day in the list. Or we will condone saying that no objection.
No, my lord, this is covered by judgment, my lord. Division bench of the Sound Court allowed.
My lord,
5 writ petition appeals, my lord. 8
Have you
appeals.
filed your objection?
I have filed my objections. My
Who
lord,
are you?
I am beneficiary.
Beneficiary.
I am the beneficiary.
No, in cases of this nature, where there are property rights are involved, how is that, how you are affected by here? When somebody is entitled for some sort, no, let's not construe it so strictly.
My objection may be taken on record, my lord. My lord, the condonation of delay, the reason given by the appellant is that they have not, the personal reason they have given, telling that they have not received the
In respect of the very same acquisition, enhancement is done.
Enhancement, yes, my lord.
In that
Connected
case,
matter.
why should they be deprived?
3,000.
We will say for the 3,900 so and so days, they will not be entitled for the interest.
My objections may be taken and then condemned.
Where is IA?
There is also Supreme Court judgment, my lord. Reason has to be stated properly. Recent judgment.
Same notification, same
Arising
village.
out of land acquisition, or you are generally referring?
No,
to-
no. Arising out of land.
Take that. Where in this case, the High Court has refused to exercise the jurisdiction. The courts have felt that it is a discretion exercised by the court, which by we will not interfere. That's the only point.
That is the only one. But reason was also not given properly. in the
Also, do
affidavit.
not dispute the fact that in respect of the very same acquisition, the amounts are enhanced.
The
by this
amounts are
court.
enhanced. I am not disputing that amounts are not enhanced.
Please come.
But
IA number.
it is not 3,400 days delay was not.
Delay. I am only on the point whether it is done or not.
It was enhanced.
IA number 1 of 23 is filed to condone the delay of.
3,470.
What is this recall order?
That was dismissed for non-compliance of office objection.
Not come, my lord.
So now, how many delays have to be condoned according to you?
No, this is the only IA that is pending, my lord. See,
Before-
three,
No, there is a
472.
condonation of delay also, main application.
Yes, my lord. That is only application.
How many times you will defer, you will come to the court like this?
No, non-payment of court fee, my lord, that for that.
Whatever it is,
That was
there is an
already,
order.
yes, please. That already disposed of, that IA was allowed. And
Which IAS
restored
was
to-
allowed?
Recall.
Recall is ordered.
Please, ma'am.
Already it's recalled.
IA number.
My
Next,
lord,
where is the second one?
Sorry, my lord, only one submission. My lord, with regard to this village, my lord, nowhere it is enhanced. My lord. With regard to this Abigere village.
3,000 is how many years?
3,000 is.
That is almost 10 years.
10 years.
More than, 10 years. 10 years.
Yes, where is the judgment you are relying on?
MFA number 671 of 16, my lord.
Where is
Collected with,
order?
order dated 3rd March 2020. The same advocate has appeared and out of nine case
Where is that order?
order, I will, this one, I will, next date of hearing, I will produce it, my lord.
When grounds for the petitioner submits that in another case, an inordinate delay was condoned by the court and he wants to
Division
place
bench
a
office.
judgment before this court. Pose this matter on 4th of September.
My lord,
Yes.
not on 4th, 5th.
5th of September.
Please.
Yes, 23.
Cell number 23.
Appellant,
Okay, sir.
pray for time to file my objections to the IA filed for
Interim order
vacating.
is still today, my lord. I am opposing.
What
the
is that, again, now, in this, no interim order, again for vacating
my
the
lord.
order,
It is.
vacating the order, another objections to vacating the interim. No, we will not look at either of the petitions, we will look at the interim order.
Please.
I mean, the order impugned passed by the trial court.
Yes, my
For
lord.
that,
For-
no objections are
Please.
required.
Yes, my lord. That is right.
Lord,
For that,
the order is still today. And my lord, I am opposing the extension of that order. It is not even the recall of.
On the minutes of it, please come.
Please.
Yes, my lord. For that, I need to place the documents which were relied upon, my lord. I have produced only.
When something is not relevant while getting
No,
an
it is a
interim
suit
order.
for specific performance.
No, whatever it is, when it is not relevant at that point of time, no, it is also not relevant. Yes.
Fair. My lord, suit was filed for the relief of specific performance seeking to enforce the agreement of the year 2012, my lord.
Date of the agreement?
Yes, my lord. One second.
Notice is not served in this. Notice is not served to all the parties.
No, my lord.
I am the contesting respondent, my lord. I am the owner.
Another.
I am the affected party, my lord, who is
Another
constructing the building.
respondent is also contesting party, my lord.
Who is he?
He is also one of the purchaser.
As long as, my lord, I am able to satisfy your lordships that the suit is not maintainable,
Yes,
then, my lord,
yes. Agreement of sale,
My lord, 16/6/2011, my lord.
16/6/2011. When is the suit filed?
My lord, suit is filed in the year 2021, my lord.
Hmm.
There is no time stipulation in the agreement of sale, my lord. It was a condition precedent,
What did you pay as earnest money?
35 lakhs as on the date of agreement, my lord.
What was the sale consideration?
75 lakhs was the total sale consideration.
What is your case?
And the condition precedent in that agreement was that the vendors therein have to get the lands converted, and immediately after intimation to me of having got the lands converted, I'll pay the balance sale consideration and get the sale deed registered. And my lord, till the year 2021, the kata, mutation and other revenue records were standing in the name of the original owner itself.
That is defendant number 1.
No. He is a defendant number 1. Yes, my lord, before the trial court. Defendant number 1 to 14, my lord.
Or the owners?
Owners.
1 to 14.
Yes, ma'am. Now, the revenue records did not change and it did not reflect that the land has been converted. Now, after entering into agreement, my lord, on 3 occasions, they have received additional advance sale consideration. Lastly, on 24/6/2019,
How much money is received?
4,50,000. In total, my lord, they have received 50 lakhs, my lord.
Hmm.
55 lakhs. Sorry. 55 lakhs was the total amount received. Suddenly in the year 2021, my lord, the revenue records stood transferred to the name of the contesting respondent.
What is number? Defendant number?
Defendant number 16, my lord.
Your defendant number 16?
Yes, sir.
Yes.
Defendant number 16, my lord.
Which year it is? When did he purchase?
He purchased in the year 2020, my lord.
Hmm. Yes.
Immediately, my lord, after coming to know about the same, I cast a legal notice to the original owners, including the contesting respondent here.
You came to know when?
2021 itself, my lord.
You issued a legal notice.
Yes, my lord.
Then what happened?
Communicating that there is an agreement entered and illegal charge has been created, my lord.
Hmm.
He is also a party to that legal notice, which was duly received.
Dated?
My lord, legal notice is 5/7/2021, my lord.
Yes.
After receipt of the legal notice, my lord, neither the purchasers nor the vendors complied with the demand made in the legal notice, and even they did not reply me. Having no other alternative, I filed the suit, my lord. Upon filing the suit, upon considering the prima facie, the trial court granted an
Defendant number 15.
15 is also another purchaser, my lord.
Hmm. Who he purchased when?
He purchased, my lord,
The date of your vendor's purchase, Mr. Counsel?
Yes.
Please
Sorry.
give the date.
Yes, sorry. My lords will see, my lord, that I'm sorry, my lord, I'll take a minute's time, my lord.
Yes.
I'm so sorry.
Now,
I'm sorry, the date is, my lord, 20th April 2022.
It can't be.
12, I'm so sorry. I'm so sorry.
20th?
20th April 2012. So sorry.
Immediately, almost after nearly 10 months after the agreement of sales.
yes.
Yes.
Now, they say that there is a deed.
But mediation is not done in favor.
No.
of you.
That I will ascertain and let.
No, is it? Yes, sir.
It is, my lord. I will ascertain that, my lord. I think it is done, my lord, soon after that.
Yes.
Now, I filed a
The
suit.
land is converted, my lord. So the agricultural, whatever attributes of an agricultural property are concerned, those mutations, RTCs, etc., don't reflect. The land is converted.
When was it converted?
Converted, my lord. Sorry.
That's why, my lord, I said
I will
raise
ascertain
the
that.
documents before this court.
The conversion document is also, my lord, I'll ascertain the date in a minute's time. And in fact, my lord, the specific government is that it was converted and then, my lord, sold to the builder. I'm so sorry.
If you have the documents, place it.
Yes, I have in fact, the entire suit, 6th January 2012.
Itself it is converted.
Yes. 6th January 2012, it was within the knowledge, and then, my lord,
Yes.
I've stated so in my stay vacating application.
Yes.
Now, if it is the case that it was transferred in the year 2012 itself, nothing prevented them from getting the revenue records transferred. Only in the year 2021, my lord, revenue records are transferred. Now, they don't deny that there is an agreement. They don't say that revenue officials have never entered the fact of there being a conversion order in the revenue records. And the defendant number 16 gets the kata mutated to his name only in the year 2021. Immediately after coming to know about the said fact, I have issued a legal notice. To that notice, there is no reply. Upon filing the suit, my lord, the trial court grants me an interim order of injunction restraining the defendants from alienating the suit schedule property and not to change the nature. Now, pursuant to granting an interim order, the defendants 15 and 16 entered their appearance. They filed their written statement along with an objection. The only reason assigned by the trial court is that agreement is of the year 2012 and the alienation and subsequent development has been done. As such, I am not entitled. The very trial court at the first instance grants an interim order. And insofar as the consideration,
Number 1 to 14 have not contested.
no, there was no occasion for them to enter upon, my lord. Immediately after granting an interim order, the defendants 15 and 16, against whom interim order was operating, they have entered up here. If they had entered appearance and denied my agreement and denied the fact of having received the sale consideration and denied the entire agreement in toto, the question would be otherwise, my lord.
Have you filed before the court that in 2019, how did you pay the money?
Yes, my lord. Appreciating that fact only,
How you paid?
my lord, by way of cash, my lord.
No check transaction,
In 19, there is no check.
only transaction in 2011.
Yes, my lord.
That is also cash or check?
That is also one, sir. My lord, I don't have the copy of that.
Copy plaint will be there.
No, in plaint, we don't say that whether it is paid in cash or we'll say that we have paid.
Paid the amount by way of so and so.
No, my lord,
This
that is absent in the plaint.
It is a specific government which needs to be stated.
That's why I apologize for this court to place a document because stage was hearing on interlocutory application. If a date is given, my lord, I'll.
No, you cannot have an interim order in your favor without filing.
No.
any the documents, you don't feel that they are necessary then for obtaining an interim order. But to vacate an interim order, those documents are necessary.
Yes, my lord, interim order was granted in the year 2023, my lord.
No, that time when it is not necessary, now also it is not necessary.
No, since your honors have asked a question, how it was paid.
That don't have to have the document. That should, your plea.
No, in plaint, it has not been avowed, my lord. It
Then
is
we have
said that has been
You
paid.
have to think that it is by way of cash when there is no other mode.
No, it may be taken up tomorrow, my lord. I'll come up.
Tomorrow.
The mode will not change.
Tomorrow, on the top of the list.
Yes,
Third
ma'am.
part.
Great.
Interim order maybe.
Interim order granted is extended.
Till only
till then.
tomorrow, my lord.
Yes,
So
ma'am.
further
Yes,
adjournments will be
that is
granted.
there.
You please prepare a chronology of your
I will.
events
I'm
and all.
sorry, my lord. I
Yes.
will.
Yes, next.
24, Karnataka.
The suit for partition was filed by the minors, my lord, and an application for injunction not to alienate and not to, application was filed and that has been rejected. Against that, my lord, this petition. My lord,
What is, how, there is a delay in this, 13 days delay. Let's see the order.
order, my lord, next
Suit of 2022.
suit of 22, my lord, 23, the order was filed, my order was passed in the year 2023, December
Let us
2000.
take out notice.
My lord,
No.
now the other side has filed and one more application saying that they have already sold one portion of the property. There is set of their alienating other share portion also, my lord.
Notice.
Now I may be also permitted to take.
Notice to the respondents, petitioner is permitted to take out hand summons on
The
the court's
advocate who is-
appearing for the respondents before the trial court. He exposes matter on 11th of September.
My lord, the other case is posted before the trial court on 28th, maybe
Of
shorter,
28th of,
this month only.
how can you issue the summons? How will they come and appear? before the
I'll serve
court?
the advocate. my lord.
28th.
I'll serve the advocate on the.
Not possible. Whatever you want to do before the court,
Okay.
we'll have it on 3rd of September. Even by that also, I have my own doubts whether you can do it or not. Yes.
Till number 25. Rajesh Shekhar, yes, for petitioner, appellant.
Appellant. First submission, my lord, there is a delay of 7 days. My lords, I have assigned the reason. I have assigned the reason that in the.
That will be condoned, for that no argument.
Yes, ma'am.
What about you?
It can be condoned, my lord. But
You are ready?
No, my lords. I got the papers yesterday itself, my lords. It may be taken up on Thursday or Friday, your lordship.
Pose this matter on Thursday. IN number 1-2 of 24 is filed to condone the delay of 7 days in filing. For the reasons stated in the accompanying affidavit, the delay is condoned.
Yes, ma'am.
Then calls for the respondent, submit that he has received the papers yesterday. Pose this matter on Wednesday for hearing. That day will dispose of.
Thursday, your lordship.
Thursday, I will hear it.
Yes.
No steps in between. Yes.
Grateful.
Pleasure.
26. Rajesh Gowda. Till number 26, Rajesh Gowda. Tenkrai Gowda for respondent.
No representation. Pose this matter on 10th of September,
Till number 27,
same order,
till number 28,
same.
Amar Korea.
You appear in
29.
29, yes.
Till number 29.
Notice to the respondents.
My lord, I'm just filing a memo.
Ah.
The amount of fraud which has been played before the trial court to obtain this order, my lords, in the year 1994, similar petition is filed. The court dismisses the petition stating that she is not.
Take out notice, we'll hear them and pass an order.
My lords, the problem is they've issued an NBW against me. I'm a 70-year-old.
When is the order impugned?
My lords, order impugned is, my lords, the year 2023.
Why you have come to court after such a long time?
My lords, there is no service of notice upon me. Now they say the notice has been served. Therefore, my lords, this memo may kindly be seen. They have affixed my signature. But the thing is,
And counsel for the petitioner submits that without any notice to the petitioner, they played fraud and affixed a signature and shown that the notice is served and certain papers were filed before this court. Considering all that, considering all that, there shall be stay of all further proceeding pursuant to the order dated so and so, so and so, in so and so. The registry is directed to issue emergent notice to the respondent. Yes.
Till number 30.
Back to APA for the respondent.
Sorry to interrupt. My lords, may I seek for hand delivery of the order?
Hand delivery of the order, yes.
Well, earlier order passed by your lordship, my lord. Your lordship is gracious enough to modify the order. And against the interim maintenance
See,
of
item number
9
30,
lakhs, 9 lakhs.
Post for dismissal. No representation for the petitioner.
Tomorrow,
Counsel
my
for the respondent is present.
Tomorrow.
Tomorrow, yes,
Please,
31.
Till number 31.
Give that order. This no, will not dismiss it. For 31, no representation for dismissal on 29th.
20.
Yes,
Till number 32,
this also for dismissal on that day.
29,
Yes, 33.
33,
Avoid service of notice, post after service of notice. Yes,
till number 34. GM Srinivas Reddy, awaiting service of respondent.
My name is Pushpalata, madam. ನನಗೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಡಿ ಮೇಡಮ್ ನಮ್ಮ ಅಡ್ವೊಕೇಟ್ ನ ಹೈರ್ ಮಾಡೋದಕ್ಕೆ.
ask her whether she can engage an advocate or we shall appoint somebody from the legal service authority.
Whether you are able to engage an advocate or any legal service.
You talk to her in Kannada.
ಮಾಡ್ಬೇಕಂತ.
What she says?
He says that
Hmm.
respondent present.
Srimati Sumitra GM is appointed as the legal aid counsel, Srimati Sumitra GM is appointed as a counsel representing the respondent. The registry shall send the papers to the counsel and a respondent is present before the court and submits that she is not in a position to engage the advocate. Yes, pose this matter on 18th of September. Tell her to go to the legal services. For the Tell her to go to the legal services.
Legal service.
Hmm. I have the chamber matter, no, at 2 o'clock.